ఎమ్మెల్యే ఈటెల రాజేందర్ సంచలన వ్యాఖ్యలు చేశారు. తన హత్యకు కుట్ర జరుగుతోందని
ठीक।
Number 1 to appeal 3, the Lal Ji Kuswaha.
My lord, this is
My
the
lord,
first
in
appeal.
this case,
My lord, this is a first appeal preferred by the appellant against the order of dismissal of the application filed by her under Order 9, Rule 13.
You have already admitted?
Yes, my lord.
Then why is it listed? IAF
for consideration of IF, but my lord, I am
My
praying
lord,
for
the application is
one
filed.
week time to file the reply of the IS, my lord.
divorce decree has
Yes.
been passed in favor of
Husband, respondent, my lord.
Respondent, my lord.
husband.
Yes, my lord.
Any delay in this filing of appeal?
My lord, 4 days delay is condoned.
Condone is हो गया है, my lord. Appeal
My lord, 4 days delay is already condoned.
It's condoned. So have you remarried?
नो my lord.
Hmm?
अभी तक तो अभी मैरिज नहीं किए, बट माय लॉर्ड माय सबमिशन इज दैट कि इसमें हमें रिप्लाई के समय दे दें और एक मीडिएशन करा लें, क्योंकि मैट्रिमोनी केस
Till then, don't remarry. We'll just say that.
वैसे भी यदि विद इन टाइम हिंदू मैरिज एक्ट सेक्शन 15 इज एप्लीकेबल हो
No,
जाए
ठीक है, but people don't understand. ना?
तो
Section 15 तो आप और हम जानते हैं, litigant नहीं जानता है.
My lord, I would like to make a small submission. My lord, the respondent has alleged false facts.
Any
in court case.
possibility of settlement?
My lord,
जब दोनों साथ में आएंगे तभी पॉसिबिलिटी है, क्योंकि थ्रू काउंसिल
तो आप लोग बुलाइए उनको मीडिएशन.
Yes.
इसमें मीडिएशन हुआ है क्या?
नो मैरिज अभी तक नहीं हुआ
पहले कोर्ट के सामने
my lord, the
एक्स पार्टी डिग्री हुआ है माय लॉर्ड, इस कारण क्योंकि
एक्स पार्टी डिग्री है.
यस
yes, my lord.
What?
My lord, the appellant has also filed a 498A case in Allahabad,
No, what
which
about 913?
my lord, 913 was preferred against the divorce order, against the divorce decree.
Hmm. So what happened to that? 913 was
My lord, application under Order 913 was dismissed by the family court on the ground that day-by-day delay was not mentioned by the appellant.
okay.
My lord, whereby in the
पेज 68 पे है 913 का ऑर्डर. 913 इसमें रिकॉर्ड तो है.
yes, my lord.
Whether 913 order is right or wrong, we'll have to see.
माय लॉर्ड सेक्शन 5 ही डिसमिस हो गई थी, इसका 913 का सुनने का कोई औचित्य ही नहीं बचा था.
क्या डिसमिस हो गई?
913 के साथ में धारा 5 से एप्लीकेशन लगाई थी, धारा 5 ही डिसमिस हो गई, 913 का कोई औचित्य ही नहीं बचा था.
All right.
तो
How much was the delay?
My lord, the delay was not explained from 31/1/2019, the date of the ex parte order, till 26 June 2019. The application under Order 9 Rule 13 was preferred.
5 months.
Yes, my lord.
All right.
My lord, whereby in the application she has stated that in the mediation proceeding, in the other case proceedings, she had got.
Record is here.
yes, my
913 का MJC का रिकॉर्ड है. ये नेक्स्ट फाइल होगी. है इसमें?
इसमें
नहीं, but
रिकॉर्ड के
what है?
एग्जिबिट भी 11 देखने में
हाँ, तो ये पूरा इसमें डिले से एक्सप्लेन किया है उसमें. वो डिले में डिसमिस करती है 913. Where is your section 5 application
My lord.
in support of 913?
My lord. My lord, it's at page number 60.
ये they've said that जानकारी नहीं थी, जानकारी जैसे हुई तो हमने मूव किया, ये सब एक्सप्लेन नहीं किया। जजमेंट पुराना कब की है? ओरिजिनल 19 का है, 22 की है।
My lord,
My lords, may kindly see page number 51, annexure 3.
थोड़ा सा सबमिशन था my lord।
सेटलमेंट के लिए इनको कर देते हैं कुछ, सेटलमेंट के लिए तैयार हैं आप लोग?
एक मीडिएशन
My lords,
क्योंकि मल्टीमिलियन केसेस
On what ground the decree has been passed?
my lords, that she was having an affair and she refused to stay with the respondent.
पेज नंबर 22 का पैरा
Then
नंबर 27
settlement, is it possible?
बट मतलब ये पार्टी के ऊपर डिपेंड करेगा, दोनों
Yes,
जब
ma'am.
आमने
Lord,
सामने
may-
होंगे तो।
My lord, may kindly see page number 51. Mediation proceedings had already happened in 498A case referred by the appellant in Prayagraj.
Then what happened?
My lord, the mediation proceedings failed, and at the mediation proceeding itself, she got the knowledge that a divorce decree, ex parte divorce decree has been
Right.
passed against her.
Then I don't think there'll be possibility of settlement.
My lord.
माला मेरा निवेदन ही था
इसको सुन लेते हैं फाइनली,
कि इसको
My
कोई
lord, stay
Finally, सुन लेते
application
हैं।
may
कोई
be.
डेट दे दे, क्योंकि हम रिप्लाई पेश कर देंगे वो इस एप्लीकेशन।
My lords, the facts alleged by the respondent in the divorce decree are false, and the appellant wants to corroborate the same. That's why a stay application
That
may
we'll
be
have to
granted.
see on the basis of
My lord.
evidence that is adduced.
My lord.
That will be a final hearing issue.
My lord. My lord, stay application may be granted. Stay may be granted on the execution.
उसको लगा देते हैं फाइनल हेयरिंग में। ये ऑर्डर तो ऐसा लगता है कि सेटलमेंट नहीं होगी, इतनी ऑर्डर किए कितने को देख सकते हैं। पहले इसको सेटलमेंट करना पड़ेगा, स्पीकी पास करना है। All right, इसमें लिखिए that
माला
the attempt towards mediation have not yet been explored. Possibility of mediation between the rival parties has not yet been explored, and therefore वो mediator appoint कहाँ की है parties है?
My lord, the appellant is a resident of Prayagraj.
Then they'll have to come down to Jabalpur.
My lord.
Jabalpur में appropriate mediator. Any comment date when you can you give?
जुलाई की
Next month, since the
कौन सी कर
rival parties have agreed to explore the possibility of settlement, the husband, the respondent husband is restrained from marrying again. IS stands disposed of.
माला
Just immediately after the receipt of the report.
मेरा सबमिशन ये था, ये रिस्टेन करने से पहले पेज नंबर 22 का पैरा नंबर 26
नहीं आप ये तो लिखा है कि इसको अगर विकेट कराना होगा तो आप ये लगा लीजिए।
मेरा सबमिशन ये था कि 27 देख लें। इनफैक्ट हुआ क्या था मैडम,
लेट द सेटलमेंट बी ओवर, 1-2 महीने उसमें लगेंगे, फिर लगेगा केस।
फिर उसका मिसयूज हो जाएगा मैडम। मेरा
क्या मिसयूज होगा?
मैं एक्चुअली
आपने
इनफैक्ट
कहा ना मैरिज नहीं कर रहे हैं आप,
हाँ मैं थोड़ा इनफैक्ट
अगर हम आपको रेस्ट्रेन भी कर लेते हैं तो हाउ डज इट एडवर्सली अफेक्ट यू?
मैं पता कर लूँगा, ऐसा तो नहीं कि मैरिज हो गई है या नहीं। ये थोड़ा सा मैं 2 मिनट के लिए मैं मुझे यदि वक्त दे दें, क्योंकि मैं डिग्री हैज बीन ग्रांटेड मैडम, ये हुआ है मैडम 2019 का।
रेडीनेस लिख दीजिएगा ऊपर, बाकी सब काट दीजिएगा। अपॉइंटमेंट ऑफ मीडिएटर उसमें लिख दीजिएगा लर्नड काउंसिल फॉर द पिटिशनर हस्बैंड, रिस्पोंडेंट हस्बैंड
इसमें
is seeks and is directed to find out as to whether the husband has remarried or not. List in the next week.
My lord, meanwhile, for the
I-
next date
I-
of hearing, I
I-
may be.
I shall be decided on the next date,
ओके
but no further time will be granted to you.
Your number 2 is Malika Hari.
Surrender. Has he surrendered? Report आई है आगे. Was supposed to surrender when?
Your Lordship,
8/5. All right. The surrender report 29/5/23 of the special judge NDPS Act Riva reveals that the appellant, sole appellant,
yes, indeed.
has surrendered on 8/5/23 in due deference of the order dated 28/4/23. The aforesaid fact is taken on record. List for final hearing. क्या चीज है? कॉन्डोनेशन ऑफ डिले. कितना डिले है? गार्जियंस एंड वार्ड्स कितना डिले है? 139 days. क्या हुआ ये डिक्री रामदास? अच्छा डायरेक्शन हो गया. ये लगता है वो ग्रैंड पेरेंट्स के फेवर में डायरेक्शन हो गया. Let notice be issued on admission as well as IAS also of condonation of delay. PF within 15 working days peremptory. Next, record be requisition. Intimation to the council of passing of this order.
Number 4, Sachin Jain.
फ्रेश केस है क्या? फ्रेश केस. Nobody is there. चलो पास ओवर पास ओवर.
Number 5, with connected matter, Sri Sivas Mohan Guru.
My Lord, I'm appealing on behalf of Sri Shivas Guru. I'm requesting for passover in this case.
No, we'll be rising early today.
Your
So
Lordship, the reply of the state and
any notice issued in this? Along with revision so and so.
not in item 5, Your Lordship.
Right. In the connected matter.
In the connected matter, state is the petitioner, Lordship.
This is against the final order.
Your Lordship.
Order आ गया है.
No,
So we'll place it next week. The record is available next. List the case in the next week as played for.
Aman Bashpa. Oblage.
Number 6,
My Lord, 6 and 7 and serial number 6, my Lord, there is delay. Condonation of delay पे सर notices आएंगे और records आएगा क्योंकि arbitration revision है सर.
Against final order.
Sir, revision final order.
All right. Records आए नहीं अभी.
नहीं सर अभी नहीं.
The record is here.
Record is सर serial number 6 में delay है सर. और दोनों connected ही रहेंगे.
You had withdrawn the application to file a
But
properly
yes,
constituted.
I have filed sir.
That you have filed.
Yes sir. That is on record sir. With better particulars.
How much is the delay? कितना delay अभी?
So एग्जैक्ट क्वांटम मुझे नहीं मालूम है सर. इसमें
तो कहीं नहीं है.
This is 2236, my lord.
So barred by 11 days. Yes, any objection?
No, your lordship.
We condone the delay condone list for admission.
Sir,
Since the record is here, after 4 weeks.
sir, I am praying for date of 20th of July क्योंकि outstation
20th July,
mobilize, sir. In both the cases, my lord.
both cases.
Mobilize. Dharmendra Soni.
Cell number 8. CGL, sorry.
Yeah, FA. फ्रेश आइए पेश करा है इसमें कॉन्डोनेशन ऑफ डिले फ्रेश आइए पेश करा है लास्ट टाइम विड्रॉ कर लिया था 14/7/2022 में किया था इसमें डिले है ना ऐसा कुछ तो लगा नहीं है जुलाई से आज 7 के बाद कुछ है क्या जुलाई 7 के बाद जुलाई 22 के बाद कोई एप्लीकेशन लगाई है नहीं लगाई this court on the last occasion so and so had permitted withdrawal of the application for condonation of delay with liberty to file a properly constituted one. Next para. Despite elapse of about 1 year, no fresh application has been filed. Next para. If a properly constituted application for condonation of delay is not filed, kitna delay hai?
I'm seeking permission. I withdrawn, my lord. Item number 8.
You want to withdraw?
I want to withdraw because of both parties are compromised.
First appeal.
Yes, my lord.
अच्छा आपका वकालतनामा है इसमें
Yes, Ram Narayan Shah.
क्या नाम है आपका
Ram Narayan Shah.
दीपिका इसमें अपलेट कौन है दीपिका JL सोनी मनोज
Yes.
सोनी भरत कुमार आर्यन शाह
Yes. Aryan Shah.
You आर्यन शाह
Yes.
अच्छा all right Shri Aryan Shah at the very outset praised for withdrawal of this first appeal by submitting that by informing that the parties have settled their scores and do not want to prosecute this appeal next month. Accordingly, IA stands dismissed as withdrawn. कोई IA withdrawal के लिए लगाया है कि नहीं? नहीं.
नहीं.
All right.
Oblige me.
Document to be. No document. There is some IA for document to be taken on record.
Yes, my lords. That is the FIR which we obtained after filing the petition.
What is the challenge here?
Challenge is to the FIR.
To the FIR.
Yes, my lords. We applied under the RTI, but we got it after filing of this petition.
So
That
then,
we kindly be taken on record.
where is the IA?
That is 145 of 2022.
IA 145 of 22 for taking the FIR. Impugned FIR
Yes, my lords.
on record is considered and allowed. IA stands disposed of. Full stop. The FA. Have you sought quashing of that?
Yes, my lords.
They said the FIR shall be considered at the time of hearing.
Only FIR.
Only FIR.
So trial is going on.
No, my lords, they have not filed the charge.
Charge sheet has not been.
Not been filed. Investigation, man, then what is the scope?
My lord,
Charge is what?
Charges is
420, 409 and 120B.
120B.
Yes, we say there is no direct cognizable offense on the face of the FIR.
List for hearing in motion after 2 weeks. You have the diary?
Can it be?
not the original? We have the duplicate case.
The diary is here, then you argue the matter.
Lord, can it be in the month of July? Mr. Dutt has to argue the matter. He's just on his way, but he has instructed me that it
In the
could.
meantime, charge sheet will be filed.
Lord,
Then
there is no interim order. They can do it because they are waiting for sanction. There is also sanction under challenge, but my lords have hold that under the
list after 3 weeks.
my lords.
Bill number 10 with corrected matters, Siddharth Sharma, Saban Usreti.
My lords, at the outset, I have a humble prayer. Yesterday only I was served a copy of an IA for recall of my lord's order of admission. My lords, I'm praying for some time to go through it and to file an appropriate response in that IA. That is, my lords, the IA number.
The IA is not listed today.
My lords, it is listed, my lords. It's 9502 of 23.
That is in the connected case.
Yes, my lords.
उसमें है क्या?
In ITA 142/2022, Lordship has admitted the question of law. Lordship, kindly see my IA, Lordship.
IA.
Yes, Lordship.
Yes.
Lordship, on third.
So are you ready on that IA?
Lordship, the question is that whether this question.
Mr. Sharma, you
Lordship, yesterday only I received a copy, my lords. I'm praying for some time to go through it and to analyze what he's trying to say, why it was wrongly admitted.
all right. Yes. So we'll take it up after the next week.
Yes, sir.
The IA for recalling of the order of admission bearing number so and so was served on the council for the revenue yesterday, and therefore said council seeks time, list after 2 weeks for the same purpose.
Both the matters.
Yes. ये 10.1 में होगा. दोनों में आइए पेश करिए.
नहीं एक में की है सर, दोनों इंटरकनेक्टेड हैं इसलिए दोनों साथ.
10.1 में ऑर्डर होगा.
Bill number 11, T. Gurmeet Singh Bikku, Siddharth Sharma.
हाँ मैंने दे दी, आपको कॉपी भी दे दी.
ये जो सेकंड चार्टर्ड अकाउंटेंट रिपोर्ट थी वो मिल गई आपको?
हाँ वो मिल गई है सर, मैंने आपके आदेशानुसार उस पर अपना रिस्पांस भी दे दिया सर.
अच्छा, वो कहाँ है? कब पेश किया आपने?
That has been filed on 1/5/23.
Yes, 1/5/23. So you've given a copy to the other side, yes.
I have given copy to the.
All right.
उनको दिया.
Yes, Mr. Sharma, are you ready?
My lords, some time to go through that response. My lords may be pleased to have it after a week.
Lordship, meanwhile, kindly appreciate order dated 31/10/22. This is for consideration of IA number.
No, that second report is in your favor or in favor of the revenue?
It is in favor of revenue, but it is
Revenue.
there is no need of that expert report.
अच्छा.
I have approved on the basis of documents.
Lordship, I'm praying for some time to file.
The problem is that we'll be rising early today. So किसी और दिन आपको convenient हो तो बताइए.
जैसा
आप यहीं के हैं, जबलपुर के हैं?
जबलपुर.
अच्छा, कोई दिन बताइए जो कन्वीनियंस हो आपको. जुलाई में कोई तारीख? उस वहाँ कैलेंडर है, देखिए नीचे.
ये आप इसमें आप देख लीजिए, कोई भी आपको ठीक लगे. 19 ठीक है. 19 में 20 है.
19 को मेरा केस लगा. 12th को. 12th जुलाई.
12. ऑलराइट.
लॉर्डशिप, इसमें आईए भी कंसीडर हो जाता.
कौन सी आई है?
13/0/2022. इसमें इन्होंने डॉक्यूमेंट मैंने मांगे थे, इन्होंने दे दिए हैं सर. The document also proves that the figures have been changed and my claim was duly scrutinized, and thereafter relief under section 89(1), that is 281, 797 was approved. और अब ये मेरे को उससे कम दे रहे हैं सर.
अच्छा ठीक है. इसमें लिखिए that due to paucity of time, with the consent of parties, the matter is posted on 12th, 12 July. All right. For consideration of the second report of the chartered accountant, and as well as IA number
13020
of
/22.
22 filed by the petition. 12 July.
Number 12, Himanshu Kempa, Abhijit Srivastava.
My lords, yesterday I received a call from the council appearing, senior standing counsel for the department. Is adjusted today, my lords, due to certain personal difficulty. So this case may be taken up next week, my lords.
Who is adjusted?
Shri Abhijit Srivastava, my lords.
अच्छा. Adjusted है क्या? हाँ? Doesn't he have an associate who can stand up and inform this instead of the opposite counsel informing?
My lords,
Huh? Yes, it is. Since the counsel for the revenue has adjusted list after 2 weeks.
oblige, my lords.
Number 13, Kishore Raj, Siddharth Sharma.
My lord, in this matter, outsider council has to argue in this matter, my lord. Kindly fixed for 25 July, my lord.
23rd July.
Yes, my lord.
Okay. What is this? IA 6222 of 23 is an application for taking document on record. Full stop. The said IA stands disposed of.
Yes, my lord.
With the observation that the document annexed thereto shall be considered at the time of hearing. Next para, it is informed by Shri
Kishore Roy, my lord.
Kishore Roy
Yes.
that an outstation counsel shall be arguing the matter on admission, and therefore a fixed date is prayed for. List on
25 July, my lord.
25th July.
Yes, my
The other side has filed the reply.
Yes, my lord.
They filed.
Number 14, Citizen Approval, Sanjay Lal.
Sir, may kindly pass.
All right, pass over. Will it be heard? Is it to be argued today?
My lord, you can list after 1 week.
Will it be heard today or not? Why should we unnecessarily pass it over? Notice was issued, reply is here.
Reply is here.
Yes, ma'am.
Yes, reply is here. Reply is there. So it was only on your behest that it got adjourned on the last occasion. 4-5.
Yes. Maybe listed after 2 weeks, my lord.
Alright, as paid for by learned counsel for the petitioner, which prayer is not opposed, list after 2 weeks.
Bless. Whenever.
Number 15, Ashok Goswal.
My lord, listed for taking the rejoinder on record, my lords. So I number 8354 of 23.
Yes, any objection? IAS so and so is considered and allowed. The rejoinder is taken on record.
It will be listed for final hearing, my lords. The pleadings are complete, my lords.
कॉपी नहीं भी दिया नहीं मिली तो होगी और एक मिनट
There is no stay.
No, my lords.
All right, since the pleadings are complete, matter can be heard on admission oblique final disposal of list after 4 weeks.
Okay, my lords.
Case number 16, the Himanshu Khemkar से class करना.
My lords, the arguing counsel, Shri Sanjay Lal, he is not available, my lords, due to certain personal difficulties, my lords. So
He is
this case,
appearing against the income tax department.
my lords, on behalf of assessing, my lords, he is
Assessing.
appearing. My lords, a week's time may be granted, my lords.
Now, we've not seen him since the time he got delisted from the income tax
My
panel.
lords, 16.
Why is he not coming to the court?
My lords, he is appearing, my lords, in the court, my lords.
He's
But-
appearing.
Yes, my lords.
Right.
Certain matters, my lords, for the Comptroller Auditor General, my lords, as well as the Enforcement Directorate, my lords. The matters, he is appearing, my lords.
Right. This is the application for stay of recoveries. He is not there today.
No, my lords, he is not available, my lords.
It is informed by Sri Khemukar that arguing counsel Sri Lal is not available. Sri Lal on behalf of the SSC is not available today. And therefore, a short adjournment is sought after, list after 2 weeks.
Oblige, my lords.
Case number 17, the Rakesh Suresh.
May I plead with your lordship? My lord, this is a regular appeal, my lord. Note, this is my lord delayed by my lord 1399 days. Notice is to be issued, my lord.
Notice was not issued. ये आपने विड्रॉ कर ली थी आइए पहले
आइए हमने
फ्रेश पेश करी
फ्रेश पेश कर दी बट आइए नंबर my lord ये 5232 supported with the affidavit where my lord at the relevant point of time I was my lord undergoing treatment in respect of my lord I met to an accident at
The delay is of 2 years. A
जी.
very long period.
जी.
Undergoing treatment for what?
The applicant my lord earlier my lord met to an accident and he was my lord undergoing my lord undergone surgery so many times my lord I have filed my lord some documents A1 and when my lord the execution case was filed A2 can be seen my lord sorry page number 9 Excel B when the my lord notice of execution my lord came to be received to this applicant then only my lord he came to know about my lord passing of the ex parte decree of divorce. Notice में can't be issued.
When did the operation take place?
पुराने डॉक्यूमेंट थे तो मिल पाए थे उसमें
ये तो सब 18 के हैं।
18 में ही डिवोर्स केस 18 में फाइल हुआ था उस समय जब नोटिस इशू हुआ मेरा निवेदन ये था सर कि व्हेन नॉट द नोटिस केम एट दैट पॉइंट ऑफ टाइम नॉट द एप्लीकेंट वाज नॉट प्रेजेंट इन द हाउस एंड एट दैट टाइम नॉट ही वाज अंडरगोइंग नॉट ट्रीटमेंट एट जबलपुर एंड देयरफॉर नॉट द नोटिस कुड नॉट बी इफेक्टेड एट दैट टाइम नॉट
Was he bedridden? Was he bedridden?
जी
bedridden थे क्या?
जी सर्जरी उसकी सर्जरी हुई थी पैर की सर्जरी हुई थी रॉड डली तो वो डॉक्यूमेंट एग्जैक्टली आई कुड नॉट फाइल
रॉड डली तो 2-4 महीने में ठीक हो जाता है आदमी
उस समय
में ठीक हो जाता है
उस समय सर उसकी मिल नहीं पाया था
we'll issue notice on that notice on the said IA
meantime record भी
PF within 6-7 working days peremptory
रिकॉर्ड भी बुलवाया सर
record
ओबलेंस नोटिस ऑन आई नोटिस ऑन आई ओबलेंस
Cell number 18C, Purushottam Soni, Abhijit Agarsi.
In this case, we were directed to seek instructions in the matter, my lord. My lord, why publishing detail?
They want to withdraw this.
My lord, इसमें application लगाई withdraw की, my lord.
Hmm. Supported by petitioners. Okay. IS also has been filed taking permission to withdraw this petition since the petitioner does not wish to pursue the cause raised herein. Next, IA accordingly stands allowed. The petition stands dismissed as withdrawn.
Cell number 19C, Ashok Kumar Jain.
Kindly this appeal be allowed to be converted into division lordship.
You have filed an application.
I'll file the application.
Conversion.
Lordship.
This is against what?
Family court.
125.
Ji.
Learned counsel for the appellant raised time to file appropriate application for converting the present first appeal into a revision list. How much time?
Within a week.
List after 1 week. List after filing of the application.
Cell number 20C, Siddharth.
So this revision against charge, lordship. Charge sheet, charge. Case diary may be called, lordship.
Where is the charge sheet?
Charge against. चार्ज के खिलाफ
हाँ, चार्ज की वैलिडिटी कैसे देखेंगे बिना चार्ज शीट पढ़े?
तब चार्ज शीट
पेश करिए।
जी सर, डायरी कॉल।
The challenge in this revision is to the validity and legality of the charge framed on 18/5/23 by the learned special judge. Next, brother. Let the relevant charge sheet be filed in hard stroke soft copy.
High document.
List after filing of the charge sheet.
Case number 21, Mala Singh, Parag Tiwari.
Made this. Because on the last date, the respondents were directed to file an affidavit. Because this is a revision against wherein after the FIR and much after the retirement of the applicant, his name was added in the charge sheet. So Mullahs had a very specific query as to how, when a procurement is done from the MP Laghu Udyog Nigam, how can the charges against the Prevention of Corruption Act be implicated against the applicant? So, and in compliance of that, they have filed an affidavit.
11/1/23, Shri Shukla is directed to comply with order 11/1. What is that 11/1 order?
Just we were directed to.
Fake firms are not identifiable.
Yes, ma'am.
Then you have filed affidavit.
They have filed an affidavit.
Stating what?
They admit to our contention. Para number 3.
Firms are not identifiable.
They say that they first admit that the purchase is from MP Laghu Udyog Nigam. So the difference was of rates, that is what they contend in the charge sheet also. That it should, the rates of the procured product, which is MS pipes, that are different. So we said that it is not a violation of MP store purchase rules. This they say in para 3, about 12th line. The present applicant sanctioned the amount of rupees 64,55,645 for purchasing the MS pipes through MP Laghu Udyog Nigam.
Then we'll have to hear it then.
But this is to be heard finally.
Probably had heard it for some time.
Heard the connected matters were heard. My
For
friend wants to say something.
May I just This has been in detail argued by me, and the other connected matters have been rejected. This was kept pending for this reason only, Manoj, that an affidavit be specifically filed as to how the offences are made, Manoj.
All right, the affidavit uh, in deference of the order passed by this court in 11/1/23 has been filed by the prosecution by way of पेश करा है
It was filed on the 15th of March.
on 15th of March. Next, the matter can now be heard on admission as well as final disposal. List on any Wednesday, Thursday.
May it be next Wednesday, Thursday, because there were earlier interim orders in all these connected matters also, Manoj, but after those, the dismissal of the other matters, Manoj, because this was kept pending, the learned court below is proceeding, Manoj, is what I've been informed, Manoj. So may it be.
With all due respect, the interim order was never there in.
So what are you challenging?
Manoj, the charges, yes, Manoj, this is a revision against charge, Manoj, framing of charges, and we had in fact filed a 482 at the first instance, Manoj. That was withdrawn, 482 petition, Manoj. That was withdrawn only with the liberty to challenge the proceedings of framing of charges, Manoj. So that is how we are here, Manoj.
Trial is going on.
Yes, Manoj. Once they admit it on affidavit, Manoj, the matter can be.
It was never there in any of the connected matters.
This is a 2012 matter, Manoj, the original FIR and the charges, Manoj. So may it be any
Other similar criminal revision of co-accused has been rejected.
Has been rejected. This was the only person who was in service.
Was rejected on merits.
No, they withdrew it.
They withdrew it.
Withdrew it.
All right, so on any Wednesday or Thursday in the
It was made be on 26th
July. In
in
August, we'll say.
3rd, Manoj.
August, mein. Any Wednesday, Thursday, August.
9th. 9 suits you?
No, let the computer decide which Wednesday and Thursday is a little vacant.
So the criminal revision would otherwise be rendered infructuous, Manoj. If they,
Why?
the charges would be framed. This is against the charges only, Manoj. That stage.
Charge must have been framed. That is why you have challenged it. The trial is going on.
Yes, Manoj.
Right.
The number 22 is
This matter was part heard, Malad. I had completed my arguments, Malad. The rejoinder arguments were supposed to be given by the petitioner.
While you kindly pass over this matter
Pass over.
or otherwise fix on 11th of July.
Now, what was this matter about?
Malad, this is the matter, Malad, may kindly recollect, where the evaluation was done in an exaggerated manner, Malad. To cause benefit to the beneficiary.
Okay. So, Mr. Mishra is here or not?
He's here, but we are arguing before the other bench.
But then today we'll be rising early, so you will have to take some other date.
Is it fixed on 11th July?
Malad, before 11th, Malad, 11 to 14, Malad, there's some medical reasons I'm adjusted, Malad.
Yes, बताइए.
10th July.
10th would be fine.
10th is a motion day. Take any final hearing day.
Post 14th, Malad, any date, Malad.
No, thereafter.
Yes, Malad.
19th, 20th.
May I have to ask this?
Yes. We are passing it over for that purpose. Please seek instruction and tell us.
The number 22. Parita Kare Purushan Yadav.
At the outset, I'm praying for withdrawal of this petition with a liberty to raise all the grounds before the trial court.
Are you authorized to withdraw?
Malad, I have my wakalatnama.
Money laundering matter.
Malad.
What? I think similar petitions have been dismissed.
Yes, Lord.
Malad.
HS Gurjar case, Lord.
What?
All the issues which has been raised in this petition has already been.
इनका वकालतनामा कहाँ है?
Sir.
होगा ना last.
Sir.
The wakalat number is contained at page number 313.
Yes, yes. Your name?
Priyank Agrawal.
Shri Priyank Agrawal. Yes, at the very outset, praise for withdrawal of this petition. Right.
With the liberty to raise all the grounds before the trial court.
Liberty to raise all legitimate contentions before the trial court.
Obliged, man.
With the aforesaid liberty. Dismissed as withdrawn.
Obliged.
Bill number 24 with connected matter.
As in compliance with the last order, I have filed the pen drive containing the entire charge sheet in one of the cases. In CRR 4272, it's 24.2.
4272. These are all co-accused.
The co-accused. Yes,
Madam. And challenges to the charge sheet.
Framing of the charges, Madam.
Framing of charges.
Yes, the entire charge sheet has been placed on record, my lord. They may verify it, my lord. This has to be finally heard, my lord.
When have you filed it?
My lord.
You've placed the hard copy.
Last week.
Hard copy?
It's a pen drive, my lord. It's a pen drive. And the document number would be 4303 of 23, my lord.
Oh, is it hyperlinked and
paging
and all?
There's only one document, my lord, of 2700 pages, and we have page numbered it properly, my lord. So that won't be a problem to, my lord, locate the page numbers, my lord.
Have you checked?
But they may verify it.
I've been supplied copy yesterday only.
The charge sheet has been filed. Soft copy of the charge sheet has been filed with an advance copy to the counsel for prosecution. Next para, the prosecution is directed to verify as to whether the soft copy of the charge sheet filed is the complete charge sheet or not. List after 3 weeks.
Right.
Sorry.
Before my senior commences, there was a direction to file the details of the bank accounts which we have defrayed during the course of investigation, my lord. I have got the details of those bank accounts. By Friday, I will be filing the entire list, my lord. It is with me. So, my lord, may keep it Monday, my lord. Keep it this matter on Monday. Monday, we'll argue it finally.
What happened last time?
Last time, my lord, there was a...
My lord, a submission was made that 46 accounts have been frozen. So my friend was directed to bring details of that by yesterday, my lord, on Tuesday. And that has not been done.
He had said that lot many accounts.
46 accounts. Specifically, a statement was made that 46 accounts have been defrozen.
Yes, it is there.
That statement,
yes.
You standing by that statement, or that was a statement in the air?
I do stand by that statement, my lord. The list is with me.
Put that in affidavit.
My lord,
No, no, we want 1 week's time to file the objection.
आप कौन है?
So from the community itself.
Are you a party?
No, it's not a
But
party.
from the community, from the Christian community.
No, you should be a party. Otherwise, how can we entertain you?
So, Your Honor, we have filed the objection in the lower court of.
No, but you have to become a party here. You have to make an application for that. When you make an application, we will consider that application. Not now. We can't hear you now.
Your Honor, the client is the member of this church.
No, you have right now no locus. Please become a party first. File an appropriate application. If we allow that application, then we can hear you. Otherwise, we can't.
We filed.
So when will you file it?
Friday, my lord. My lord, by Friday, I'll be filing these documents, my lord. The details of these accounts.
My lord, if I may make a submission, my lord. My lord, just if we can, the matter could be concluded. If my friend is, just peruses documents and sees, those accounts do not belong to the church. Those are accounts of the school. My entire case is only with regard to the accounts of the church.
No, but
They are not able to distinguish that.
no, but something that fell from him during arguments. We have to give some credence to that, and
If he can just see it just now and also submit it, he can produce his documents before my lord may see it. These are accounts of the school. It has nothing to do with my case. I'm not asking any relief against those accounts. I have nothing to do with those accounts. I don't control those accounts or anything. They're the school accounts. What I'm seeking is that the church accounts, which is not a part of the investigation also today. And those accounts are meant for the day-to-day functioning, running of the charitable homes, etc. Wages of the employees.
You file an affidavit.
I'll be filing it by Friday, my lord. May keep it on Monday, my lord. We'll argue it Friday.
All right. The learned counsel for the prosecution seeks and is granted a short adjournment to comply with the order dated 23/6/23, latest by Saturday is working. Latest by
Well, it may be
July.
kept on Friday so that I can file my response on Saturday.
1st of July, we let them file it latest by 1st July, and then we'll hear it next week.
First of July. Next week, madam. I'll argue it Friday.
Accordingly list the case next week.
My lord, can I request, my lord, on 4th and 7th I am out. 4th I'm in Bilaspur, 7th I'm in Indore.
Except 4th and 7th.
My lord, can it be kept on Monday at top of the list? Because, my lord, this account has been frozen in September. My lord has given me liberty. I have first gave them liberty, then gave me liberty. And still the matter is not being
Third
decided.
okay for you?
Third.
He was asking for third, my lord. My lord, with the request that it be kept at top of the list, my lord. On this, because, my lord, this is the third or fourth adjournment, my lord. That's right.
So that's fine, but there may be there may be cases. No, there may be cases on that day which are more urgent than your case.
That is
we
true.
don't know.
I'll make a mention.
You'll make a mention.
I'll make a mention,
Okay.
my lord.
The number 26 with connected matter is Siddharth. Confess to please.
Yeah.
My lord, I'm praying for Passover.
What is the
My lord,
against what?
Amendment number 26, my lord, that's MCRC 5081/2023. At the very outset, I'm praying for withdrawal of this.
You're withdrawing this?
Yes.
What? Okay. This is against what?
The warrants of arrest have been issued at the time of filing of charge sheet.
Acha. Then what happened? He's got bail.
He wasn't present before the court, and then warrants have been issued regularly.
What is called anticipatory bail?
No, my lord. We had filed an anticipatory bail application that was rejected.
Absconding.
So I'm praying for withdrawal. I had gone through the.
Any objection?
No, man.
Any interim order in this? No.
No, man.
What? He is not cooperating.
No, my lord. Since beginning is not.
Acha.
It's observed by the learned trial.
The learned counsel for the petitioner at the very outset. I hope you are authorized to withdraw.
Yes, my lord.
Huh?
I am.
क्या नाम है?
Nishank Pal Verma.
Okay. Place for withdrawal of this petition. Challenging the order dated
23/11/2020.
23/11/20 of the.
27 just vice.
उसमें भी आदमी पहले से ही हुआ है। 23/11
27 just vice.
23/11/20 and 2/11/22 of the special judge CBI Bhopal. Next one. The present petition accordingly stands dismissed as withdrawn.
My lord, वो 27 just vice का order है which is under challenge because tomorrow they'll say, my lord.
In the relief clause, I was reading from the relief clause.
We appreciate, my lord, page number 30. This is the order which says, my lord, that
No, please read the relief clause 2311 and 211. Is it wrongly typed?
Maybe, my lord, because if my lord may kindly appreciate page number 30, this is where, my lord, their application seeking rejection of cancellation of application.
It can
Cancellation of warrants.
2311 का कौन सा order है?
23/11/2020 warrants of arrest have been issued.
Huh. But then they moved an application seeking cancellation of those warrants, which were considered on 27/10/2022.
2311 and 27.
10/2022, page number 30, my lord.
अच्छा अच्छा, तो इसमें 23/11/20 दो डेट्स है ना, तो काट दीजिए 23/11/20 एंड
27 and
27/10/22.
नहीं 211 भी है,
2/11/2021.
इसके पहले वो 211 में आई थिंक इज द ऑर्डर 211 ही है वो 211/20 ठीक है वो 27/10/20 एंड 27 नहीं 23/11/20 एंड 2/11/22 हो गई. You just check up and tell us if there is any.
No, they have given me the wrong this thing, compilation.
No, the order is not typed in sequence.
Yes, ma'am.
Second page I think is here, and then you
But
just
now-
check up.
If any,
What you have written is wrong, then please
if
tell.
any change is there, I'll make a
Yes. So which is withdrawn?
26.
26 only.
CRC 5081.
Only 26, my lord.
Yes. And remaining two.
The remaining two were connected, my lord, on account of the fact that this petition was there and the crime number was common.
My lord, for 26.1, I was seeking password.
They were of co-accused.
They pertains to co-accused, and these are the petitions, my lord, where the framing of, they have come up against framing of charges, my lord.
Framing of charge.
Yes.
So then, is it a single bench matter? No.
Earlier it used to be listed before
PC
the
Act.
single bench. It is the charges which are there, my lord, it is only 120B and 420.
Not PC Act.
Not PC Act, but if 120B is
And
my
in the
lord,
connected case?
it wasn't connected earlier, my lord, but because of the crime number was common, it was connected by the computer, my lord. But initially it used to be listed before the learned single chain. There is no charge sheet, my lord, they have not yet filed charge sheet.
The main accused, against the main accused, PC Act provisions are alleged.
My lord, against the public servants, the PC Act is alleged.
They are non-public servants.
These are non-public servants.
Right.
These are the beneficiaries, my lord.
So I think this should also be heard by this bench.
Because 120B is there.
My lord, it may be taken up in paso bataunga. For any short period.
Or we'll place it on some other day.
My lord, certainly.
All right. Charge sheet copy is filed?
Not yet.
Soft copy?
Not yet.
Lordship, I am appearing item number 26.2 and seeking 2 weeks time, more time to file a charge sheet in the matter.
In which case?
26.2.
26.2.
Yes, ma'am.
नहीं, इसमें 26.1 में आपने पेश करी है क्या? Have they filed it?
No, my lord.
Filing charge sheet, they filed it. 5/6/23.
No, my lord. Charge sheet is not filed, only few documents have been filed.
Achha, achha. The learned counsel for the prosecution, Shri Dubey, informs that the charge sheet filed by the petitioner along with covering memo on 5/6/23 is not the complete charge sheet. Next panel. The petitioner is directed to file the complete charge sheet. Hard copy stroke soft copy as the case may be. Just convenient. This may be 26.2 maybe. As prayed for, time is granted to the petitioner to file charge sheet. Within bracket, hard stroke soft copy.
Okay.
After 4 weeks.
Right.
My lord, in serial number 22, the date is 18 and 19 may be given.
18, 19. Who is there for the other side?
My lord, I am appearing, my lord.
Any objection?
No, my lord. 18th or 19th, any date.
उसमें note कर लीजिए 18, 19. Item number
22.
22.
Yes, ma'am.
All right.
Okay,
18th of July.
Yes, madam.
All right.
Nikita Gaurav.
Yes.
Obliged.
Right, madam.
Bill number 27, Shri Asif Goel, Siddharth Sharma.
Madam, I'm praying for myself for myself. Again, counsel is on his leg for 1 hour.
No, who is for the appellant? Ashish Goel. You are for the respondent.
My lord, it's income tax appeal.
No, it's by the SSE. Income CIT is the respondent here. IT at 205 of 16. Huh? No.
I'm from the department for the revenue.
चलिए इसको पास ओवर करिए. Let him come. Last time भी नहीं आए.
Bill number 28, Ram Sahodar Tiwari, Pradeep Kumar Kaveria.
Lordship has filed some documents having IE number 11286 on 9th September 2019. But copy was not received by me.
When a copy received, it's not possible that without receiving the copy, although I will supply another copy, but it is not even possible that till the time the opposite counsel is not provided a copy, the registry does not accept the application. This is an application in which I have stated that the divorce I filed in, I being the wife, I have filed an application under section 13 for divorce. That has already been allowed. And this first appeal is against an order passed under section 9 of Hindu Marriage Act. So ultimately, my lord, that order.
Who has filed the divorce petition?
My lord, divorce petition was filed by the wife. That has been allowed.
That was allowed.
That has been allowed. I filed that order sheet, my lord, along with an application.
When was it?
My lord, that was allowed.
Passed?
My lord. Lords, that is
After this 9 degree.
My lords, after that decree, my lords. That is order dated, my lords, 24th of August.
No, that 9 petition was dismissed.
My lord, that was dismissed. That was filed by the husband. Against that, this.
So now what is the value of this?
Nothing, otherwise. That is what my submission is.
Section 9 section.
Lordship copy तो मिले मुझे. इनने क्या पेश किया है? Without the copy, how can I argue?
All right. Where is that order?
Lords, that order I filed along with the application. Lords.
Order इनने दिया है.
That is IA number 1286 of 2019.
What are the documents?
Ex parte decree of divorce हुआ है. हाँ, नहीं इनका कहना है divorce petition wife के अलाउ हो गई है. Where is that order?
That is IA number 11286 of 2019, my lords. That is application for additional documents on record.
कहाँ है भाई? 11286 इसमें तो लगाया नहीं है. इसमें कुछ नहीं लगाया. क्या वो है? मतलब एक्स पार्टी है वाई पार्टी?
कॉपी रिसीव की.
विपक्ष की तरफ के रूप
के कैसे हो जाएगी सर? तो कॉपी दे देता हूँ, इश्यू नहीं है.
तो रिसीविंग भी नहीं लिखा पाऊँ सर. अगर मैंने लिया है कॉपी तो रिसीविंग हो.
कहाँ है वो? डॉक्यूमेंट नहीं है. लगाया नहीं क्या?
कुछ भी बोल रहा है.
You only provided one copy. Not
only.
In the main copy of the IA, there's no.
But it is wrong.
Even the registry would have accepted.
It is wrong submission before this honorable court. I have supplied the copy.
All right. इसमें देखिए.
It is wrong submission.
Wrong submission.
Copy received Sandeep Singh, ये कौन है? 9919.
Not Sandeep Singh.
Anyway, लिखिए इसमें
Sandeep Singh does not belong to me.
appearance डाल के इसमें लिखिए that this appeal is against this appeal filed by the husband is against rejection of a petition under section 9 filed by the husband. Next para. The counsel for the respondent wife has filed IA for taking document on record which is accompanied by a judgment and decree dated
24/8/2019. That's 24th of 8, 2019.
24th of August 19. Of divorce, granting divorce to in favor of the wife. Next para. Let a copy of the IA be served on the counsel for the husband.
Obliged.
Within 2 days, this in the next week.
Obliged.
Bill number 29, Chandrakumar Singh, Sant Jain.
Condonation of delay. What delay?
Probably that had already been considered. The matter was sent for mediation, my lord, in fact.
Fail हो गया.
नहीं हुआ सर. 216 days is the delay minutes.
तो कंडोन हुआ नहीं लगता.
नहीं हुआ सर.
Mediation has failed.
My lords.
Right. This is against what?
But it's against a judgment of ex parte order of judgment and decree of divorce and alimony.
Ex parte.
Ex parte.
What about 913?
But in fact, we
the wife,
against
the divorce decree is in favor of the wife.
Wife, my lords. The court has presumed service of notice. In fact, but the facts are like this, not that.
So there was no 913 filed.
No, but in fact, the court has not treated this to be an ex parte matter, lords. The court presumed that the notice has been served and I have not participated in the proceedings.
Good. इसमें लिखिए the mediation proceedings. ऊपर लिख दीजिएगा that any objection to the condonation of delay. This is by the husband. The counsel for the respondent wife does not object to the IA so-and-so, which is an application for condoning so-and-so days of delay in preferring this appeal. Full stop. Accordingly, IA stands condoned. The delay in preferring this appeal stands condoned. Next brother. The mediation proceedings have failed as per the report dated 25/5/23 of the mediator. Due to absence to nahi hai. Through video conferencing from USA, video conferencing. So where is the wife?
She is in Bhopal.
She is in Bhopal.
Studying.
The appellant is abroad.
In US.
All right. The appeal accordingly stands. Appeal being arguable is admitted. List for final hearing.
There is interim orders may kindly be continued.
What is the interim order?
Lord, there is stay of the implemented.
Interim order shall continue till the next day. List for final hearing.
He is also pending for vacating of stay. It may be heard finally for motion stay.
No, every case cannot be heard finally in motion.
My IA is pending, my lord, for vacating of stay.
On what ground?
What had happened, my lord? The appellant appeared before the trial court through a counsel. Later on, the counsel did not turn up in for the subsequent proceedings.
I'll put it, my lord, the council, my lord, moved an application on my coming to know that that a case has been filed. Because the appellant was in US, he sent a counsel with an application, my lord, that he be permitted to be represented through counsel. The court rejected that application and said that that application would be considered only when the appellant appears in person.
Because the matter was
So no notice was ever issued, no notice was ever served.
for the mediator.
No, there were 6 hearings which took place, and the husband and wife both participated virtually.
No, man.
No, in the mediation.
How does it matter if they did not physically appear? In mediation, they appeared virtually.
Mediation, and I would have appeared, my lord, and my prayer was that I may be permitted to appear through counsel before the court below. The court rejected that application and insisted on personal appearance.
Was
never issued any notice.
Initially referred for mediation before the mediator, my lord. Therefore, the counsel was not permitted to participate in the mediation process. How could it be? So the court has directed to direction for the presence of the appellant. Since the appellant did not turn up, my lord, the court proceeded further and pronounced the judgment ex parte.
So, my lord,
this was the case. And otherwise, my lord, at this stage, my lord, the wife is ready to settle the dispute once for all, as per the direction of this honorable court. The alimony amount was granted rupees 25 lakhs that may be modified or may be reconsidered, my lord, before the court.
So you want another mediation?
No, my lord.
But in fact, we will, at our own level, we will make an effort, my lord. That is what I assured my friend also, that the mediation may have failed, but I'll regardless.
Based on a one-time settlement. Right. Final hearing के बजाय इसमें वो काट दीजिए, उसमें लिखिए that at this juncture learned counsel for rival parties do not dispute and there is still possibility of settlement between the rival parties. Next para. The learned counsel for the rival parties are granted another opportunity of 4 weeks to seek instructions and make efforts towards settling the dispute. Failing which this court shall consider the merits of the matter. List after 4 weeks.
Interim orders may kindly.
IR to continue.
Number 13, Sanjeev Kumar Mitra, Kumar.
Because this arbitration appeal arises out of an order passed under section 34 setting aside an award.
Yes.
This matter in a different bench composition was heard by this honorable court at length, on thereafter it was released. My only request would be that if Maloj could grant us a fixed date, because this would require some time for arguments. And my humblest submission is this, that the entire impugned order passed by the district court is on the basis of a judgment passed by this honorable court, which was subsequently reversed by the honorable Supreme Court. So my entire request is that of a remand, subject to what my learned senior has to say.
No, my lords, I will have serious.
Certainly, my lords, if my lords could grant us a fixed date.
The parties are at consensus that the case has to be finally heard since pleadings are complete.
Yes, my lords.
Next list on any Wednesday, Thursday in the month of August.
Grateful, my lords.
Number 31, Sri SKC Verma.
Please, your lordship. Lordship, notices are to be issued to the newly added respondent, lordship. By way of amendment, we have implemented the maternal grandmother as parties. Respondent number 2.
So where is the IA?
IA has been allowed, Lordship, and IA is allowed on 15/6/2023, and newly added respondent has been incorporated, respondent number 2.
Okay. The newly added respondent is also served.
Is served?
Yes. है तो बहुत पहले सब हो गया.
इस पे नोटिस नहीं है लॉर्डशिप, अभी 15/6/2023 को.
ये तो पुराना है, सितंबर 20 का. नहीं न्यूली एडेड का.
Newly added IA number 7710/2023.
This was issued or not?
No, Lordship. Notices are to be issued.
अच्छा. इसमें लिखिए that अलाउ नहीं हुई है. ये अलाउ हुआ है नहीं.
15/6/2023, Lordship. 15.
Let notice be issued to the newly added respondent number 2 on payment of PA within 7 working days peremptory. Returnable 6 weeks.
Obliged, Lordship.
Serial number 32, P10 to 10. Abhishek Singh.
Army counsel or the respondent is connected through video conferencing. If connected.
Very short question is involved to this one.
Yes.
In fact, an application under section 34 was filed, and that was turned down on the ground that the Bhopal court does not have the jurisdiction. Now, initially also, the dispute travelled and an application was filed with the respondent under section 9. At that point of time, that was the first order which was passed by the court, my lord. The commercial court Bhopal held that it had the jurisdiction but rejected the application. That is different. But as far as the jurisdiction was concerned, it was held that this court has the jurisdiction. We have section 42 of the Act. I just come down to the first order and the second order, which the same court says. Firstly, it says that have the jurisdiction at Bhopal, and then subsequently it says, no, it doesn't have the jurisdiction at Bhopal. But the sole question would be resting upon section 42 of the Act, my lord. But we kindly come to Annexure A2.
Mr. Khalid, this may take some time.
Because on 30th, my lord, the term is up to 30th.
Well, now the term will not be up to 30th because I have moved to the Delhi High Court under subsection 5. And so the second proviso to section 29A4 will be attracted, and now the term will be till disposal of that application.
But in fact, that application would also be without jurisdiction. Because the entire jurisdiction would be resting upon the Bhopal court. We just have a look at the first order which is there.
Which application have they moved?
Section 42.
Section 29. We have moved an
application to 29A, my lord.
For extension of time before Delhi High Court, my lord.
Yes.
In fact, that court would not have the jurisdiction. This is what, in fact, the total case of this, my lord, that Delhi courts doesn't have the jurisdiction at all. Just take 2 minutes, my lord is kind enough to look to one provision and 2 orders, one line of the order in both the cases.
So can it be heard on some other day because we'll be rising early today?
Can it be on 30th, my lord?
No, 30th, this bench is not there.
Yes,
no, some other bench would be there. There's no problem.
Third or fourth, any date which is convenient to my lord.
No, counsel for the other side.
Subject to the convenience. He's there on the VC, but it will be convenient for him.
Yes, my lord. Whatever is convenient to my lords and to my learned friend is convenient to me, my lord.
All right. We'll adhere to paucity of time. And as agreed to by the parties, let the case be taken up for. Can it be 12th or 13th July?
11th.
11th is a Tuesday.
Tuesday.
Motion hearing day.
12th.
12th will be okay for the other side. 12 July.
Yes, ma'am.
12 July.
But till such time the proceeding at the other places they will state because the entire jurisdiction lies at Bhopal, my lord.
No, but they have just filed it. There's no order as such. They just filed it.
Shantanu Saxena.
Yes.
Obliged.
Bill number 33, GBC, that was is out.
Lordship, matter pertaining to against the divorce, Lordship. It may be sent to the mediation, Lordship.
Are you ready for mediation?
May be sent to them.
What is under challenge?
They have challenged the decree passed by the London Family Court whereby I have been granted divorce, but I am the wife, Lordship. I have filed an application before the London Family Court, my lord.
No, if you are ready, because it's you have sought a decree and you've got one decree. Are you ready for mediation?
It may be sent for mediations.
All right.
If it will be
Mediation
settled, then
parties, the council for parties are at consensus that the possibility of a settlement cannot be ruled out. Possibility of settlement with the among the rival parties cannot be ruled out, and therefore the same can be explored by way of mediation. Where are the parties situated?
I'm living in
Hoshangabad district, Lord.
District of Hoshangabad.
Both of them.
So I am living
hold the mediation there.
Sure.
Hoshangabad. Hoshangabad detail. Let them participate in the mediation proceeding there at Hoshangabad.
Some date may be given.
The list after receipt of the mediation report.
No, my lord, for mediation, there's some date may be given.
आप बताइए कोई common date?
जुलाई में हो सकती है
First, second week of July.
सेकेंड वीक में रखना
On 12th of July.
12th, first date.
Obliged.
Bill number 34, the connected matter.
These matters have to be heard finally, my lords. These are the matters relating to SVLDRS scheme, my lords. And we have already filed our reply and even our additional reply, my lord, to their rejoinder.
My lord, these matters will take time, my lords.
All right, due to paucity of time, let the case be taken up after 2 weeks.
My lords.
Obliged.
Obliged, my lords.
Bill number 35, Virajmani Mishra, Gautam Prasad.
My lord, matter pertains to the refund filed during the pandemic period, my lord. Limitation.
We are hearing it finally.
My lords. There are certain judgments on different high courts. They allow the limitation.
So that relaxation which was generally granted by the apex court during that
My
COVID-19
lords.
pandemic, is it available for this refund also?
My lords.
Here is the issue is very much different, my lord. Though this pertains to the extended period of limitation, but it is not solely on the question of limitation. It is also on the question of merits also. These cases
Then it will take time.
It
My lords.
Due to paucity of time, let the case be taken up after any interim order
No.
No, my lords.
after 2 weeks.
Grateful, my lords.
Bill number 36, Nitin Agrawal, Gautam Prasad.
This matter also pertain to Sabka Vishwas scheme, SVLDRS scheme, my lords. On the last date of hearing, my lords, order sheet may be produced, my lords. They have sought time to file the additional return to the rejoinder I have filed, my lord.
I'm speaking 2 weeks time, my lord.
So this
What
may,
time?
My lord, I'm 2 weeks time.
Any objection?
my lord, this may be as a last indulgence, my lord, because from the month of January, my lord, this has been stretched on the same
As prayed for by the Council for the Revenue, Shri Gajen Singh Thakur. Last indulgence of 4 weeks is granted to file a response to the rejoinder of the petition after 4 weeks.
My lord, it may be noted as a last indulgence.
We have said that. Yes, last indulgence.
Item number 37, my lord, the arguing counsel is not well, my lord. He has informed me that date may be sought out.
Mr. Dhyani?
Dhyani.
Yes, any objection?
No.
The arguing counsel on behalf of the petitioner is informed to be unwell just after 2 weeks.
Obliged.
Number 38, Shiv Kumar Singh, Asma Prabha.
Lord, I'm appearing for respondent number 3, my lord. Lordship, I'm seeking 10 days time to file reply, my lord.
Who is number 3?
Corporation, my lord.
Municipal Corporation.
Yes, ma'am.
कहाँ का भोपाल है जबलपुर?
जबलपुर.
भोपाल जबलपुर. No, this matter probably we were hearing yesterday or day before.
No, but,
Same
the
person.
482 was before your lordship, not?
Same person.
The person against whom sanction was refused earlier, not? His name was deleted from that matter, not? Because sanction was refused. Subsequently granted, so it has been challenged here, Milords, on the ground that Nishant Sarin covered the field and there could not have been a review of sanction on the same material.
Right. And so who is the contesting respondent?
Corporation is the
Corporation.
Who is the disciplinary authority?
No, the disciplinary authority is the mayor and council.
Mayor and council.
Which considered earlier, Milord, refused and subsequently granted.
No new material.
No new material.
Right. All right. Sri Jay Shukla appearing for the respondent number
3.
3. Why is Commissioner Jabalpur Division impleted?
Well, he was the one who proposed.
Lord, he has passed the order, my lord.
He's passed the order.
Yes.
So another aspect is, my lord, he was the administrator at that time because the corporation was not in session.
Waiting for so and so is place foreign is granted. How much time?
Lord, within 10 days we are filing it, my lord.
Granted 2 weeks time to file response.
Interim orders may kindly continue.
Just after 2 weeks, I have to continue. Till then.
Obliged.
Number 39, P.I.O. James, Raj.
Lordships, it was informed to me by counsel for the respondent that he's suffering from some serious ailment. So he's
Who is not well?
Mr. Rajeshwar Rao, my lord. So it can be adjourned to next week, my
It
lord.
is informed that the arguing counsel on behalf of the petitioner.
Respondent, my petitioner, I am ready to argue, my
The
lord.
respondent.
He insisted me
Is unwell.
Correct.
तो ये वो आ गया रिकॉर्ड लिस्ट आफ्टर 4 weeks. ये तो और भी है 45 तक है
Number 40, Sanjay Kumar Agarwal.
40. अच्छा ये
Lord, in this case, an IA moved by the state government is pending consideration, my lord. we are seeking to transfer certain principles from one college to other, three principles rather, and wide order dated 20th of April 22. In this case, this Honorable Court directed that leave of this Honorable Court may be sought to transfer any of the petitioners or similarly situated persons. We are not transferring any of the petitioners. We are transferring certain principles. And none of the petitioners is even a principal. But in view of the fact that there was an interim leave, we thought it fit that we should seek leave of this Honorable Court to even transfer the principles in respect of whom the appointing authority, the state government only under the rules which are impugned in this case, my lord. My lords directed that first we should file the reply. We filed the reply, my lord. My lords then directed we should file the parawise reply, my lord. We even filed the parawise reply. My humble submission is that, my lord, at least this IA, my lord, they are not getting prejudicially affected in any way by transfer of the persons who are not even party to this petition, and not even any person of the class of the principal is even party to this petition, my lord.
You are not transferring the petitioners.
No, none of the petitions, not even any lecturer.
Why file an application then?
Because my lords have observed that transfer the petitioners or any other similarly situated person.
Where is that?
My lord makes the order dated 20th of April 22. Down below.
Achha, what are the similarities?
So legal advice was given that it should be proper to seek leave because.
All right then, what is the urgency?
My lord, the administration of the institutions is getting affected. My lord, there was, in fact, they have not even filed any response to that IA. They are simply opposing it without furnishing any reason. Otherwise, as well, my lord, the dispute involved in this petition is settled by the division bench of this Honorable Court. We have pointed out, my lord, so argued, if my lords may remember, that even before the issuance of the impugned rules, the erstwhile rules, also this Honorable Court, Annexure R8, page number 96 of our reply, division bench order is there, held that we are very much within our powers to transfer them from one autonomous, and we transferred them, and that was upheld by this Honorable Court. Page 96. R8. We may be permitted and it may be listed for final hearing.
What about this IA? Yes, Mr. Agrawal.
Lord, may kindly have a look at the order dated 12/4. Because an order not that this petition itself will be heard finally. Because the very challenge is to the competence of the rule making authority to frame such rules.
Final hearing की तो बारी नहीं आ रही है. So then we have to take some decision on this IA.
Lord, these principles, my lord, though the appointing authority is the state government, but these principals are also employees of the autonomous body, and they are also governed by the same set of rules. Now, the transfer of these principles would also be, my lord, contrary to their rights, my lord. They are the employees of a particular autonomous body, my lord. They cannot be transferred, they cannot be compelled to serve another employer, another master, without their express consent. The law is settled in this regard. Now, the rules only provide for a transfer simpliciter. It does not even provide for transfer on deputation for a specified period.
Which rule?
Rule 7.2.
7.2.
So first, if your lordship may have a look at the rules. The rules have been framed by the state government under the proviso to Article 309 for regulating the service condition of autonomous bodies. Now, proviso to 309 empowers the governor to frame rules for recruitment to public services. Now, this is not a public service, this is service of an autonomous body. So, the very competence of the state government to frame such rules, that is under question. These are private societies, registered under the Society Registry Karan Adhiniam. Whether the state government can frame rules for regulating the service condition of these employees.
So these rules have been framed after superseding the earlier rules.
Yes, Lord.
Those rules were also made under proviso to 309.
Yes. And there is a
2010.
Yes.
R8 is a judgment interpreting those rules. Page 96.
2010 rules were not framed, my lord. If your lordship may kindly have a look at the rules. Page Annexure P9. My friend says yes, my lord.
No, 2010 rules are there on record.
Yes, my lord. Annexure P9 at page 48.
40. Yeah. This is Panjiyan Praman Patra. 40.
And they also had a stipulation for transfer
इसमें
in Rule 6, my lord.
Where are the rules?
Annexure P9 मतलब page 48.
P9, yes. It's 2010 rules.
मतलब ये नियम मंत्रालय बल्लभ भवन भोपाल से सरकार के द्वारा ही बनाया गया है।
They have been framed by invoking what power, ये नहीं लिखा है इसमें. ट्रांसफर कहाँ है इसमें?
इसमें Rule 6 में 1 ग है और nevertheless these have been interpreted by the division bench of this court. The judgment is in Annexure R8.
एक मिनट, let Mr. Agarwal submit.
I apologize.
एक बार देख लें सर इसमें कहाँ
उन व्यक्तियों का स्थानांतरण द्वारा जो ऐसी सेवाओं में ऐसे पद
by appointment.
this is only for recruitment.
Recruitment. This is a mode of recruitment, my lord. By transfer they can appoint. Yes. If a person applies,
प्रारंभ होने के बाद सेवा में भर्ती निम्नलिखित तरीकों से की जाएगी. अच्छा. So this does not govern transfer of service.
No, but this one
Which provision of the earlier rules govern transfer?
My lord, may appreciate the judgment which we have filed at page 96 of our reply, R8.
Present rules.
In respect to 2010 rules, the rules which are just now being read by my lords, the same rules were interpreted and the power of transfer was upheld, my lord.
Where is that?
That is R8, page 96.
No, that is because they said that the government has deep and pervasive control over the institution.
effort 110.
But this is the law. This is the law.
Institution.
And these were the earlier rules. And they were appointed not even under the 2010 rules. They were appointed prior to that. When 98 rules were there.
So some other persons except these 9 petitioners have also come.
No.
There are only 9 in the cadre.
No, there are several other persons. These are lecturer, professor, and readers. The petitioners are lecturer, professor, and reader. And there are several other teaching employees.
Well, the problem is that how will this administrative problem be resolved by the state?
This is not an administrative problem because these are autonomous body. Transfer is not necessary.
So they should make recruitment at their level.
The post is not lying vacant. They are making a chain. So Lordship may see proposal. One person is being transferred from Burhanpur to Ujjain. Ujjain person is being sent to Gwalior. Gwalior person is being sent to Jabalpur.
Where is that?
So it is not that posts are lying vacant. The Lordship may see their application. Next R2. Jagesh Chaurasia is being sent from Ujjain to Burhanpur. Burhanpur principal is proposed to be sent to Gwalior.
No, just a minute.
Gwalior is proposed to be sent to Jabalpur.
This is 29/9/22.
Yes.
Order.
Proposal. This is the proposal.
Prastav,
So it is a chain transfer, administrative transfer. Not that, my lord, they are trying to fill up a vacant post.
ये प्रिंसिपल्स का पूरा कैडर अलग है रूल्स के अंदर. और ये एडमिट भी कर रहे हैं उसको।
नहीं, मैंने कहा
और ये-
मैंने क्या है admit? Sir, I say only the appointing authority is the state government.
Yes.
But ultimately they continue to be employees of autonomous bodies. Even principals are employees of autonomous body. Now, how can principal be also transferred from one autonomous body to another autonomous body?
They are not agreed. They are not the principals. Any of the petitions not
challenge the validity of the rules. It is
not of the IA.
Tomorrow will become principal also.
So what happened to this order passed in 22? Is it still in existence, this order?
Which order?
Transfer order.
No, my lord, we are seeking leave to implement that
It was
order.
only a proposal. On that basis, they sought permission of this.
This is quite old, 10 months. 10 months have elapsed.
My lord, we have immediately approached this honorable court. My lord said that file reply, then file parallel reply.
How are those vacant posts? How are you managing with those vacant posts?
No, we are transferring one principal to the other on the basis of administrative exigency, my lord.
No, that's fine. But the vacancies are still there.
No, my
Because
lord.
you are unable to implement this order because of the interim order.
Because of the interim order, we thought it proper to seek leave of this honorable.
Fine. But how are you managing the affairs there?
No, affairs are being managed, but not effectively because
somebody
we realized that the affairs are not being managed in the proper manner. Therefore, my lord,
so a professor must be officiating as a.
These are principal. They are continuing on their respective post. This is only a
cadre is
proposal
the-
transferring one principal to another college. So if the order
No,
not
to
been
fill up a vacant post or to.
No, we are transferring.
Or it's a chain
No,
reaction.
this is not a rotation. We are simply transferring them from one to the other.
Where have you said this?
That's in the proposal itself.
So then what is the need of doing this?
सिर्फ ये कहना है कि 17 साल से काम कर रहा है, एक 14 साल से काम कर रहा
My lord, we have stated that लंबी अवधि से
लंबी अवधि.
so and so.
But he's not a government servant.
But my lord,
That is yet to be decided.
My lord, I beg your pardon. No, that has been decided. That's what I have stated in para R8 is the judgment. Earlier as well, जो अब specific rules आ गए हैं जिसमें ट्रांसफर पावर है, उसके पहले जो rules थे जिसमें कि ऐसा कुछ specifically लिखा था, even under those rules this honorable court held.
These are aided institutions.
No, my lord.
They're not aided.
They are fully aided, in fact, fully funded by the government, my lord. They are fully funded, 100%.
By the government.
My lord.
Yes.
Not granted it, fully aided, yes.
गवर्नमेंट कॉलेज के ही
हमने क्या था 90s में we have been trying to develop a way to run these institutions in an effective way, but never ever they were conferred complete autonomy. I have brought out the entire development from stage by stage as to how we initially thought we will form autonomous societies.
माइनॉट इसका बाय लॉज पढ़ लिया जाए तो बड़ा कंफर्म क्लियर हो जाएगा कि वास्तव में इसका
Actually,
एडमिनिस्ट्रेटिव
in
पावर
fact, you should have asked for a vacating of that part of the order which makes it an order in rem.
We have not filed a response. I refused that when they approached me that we are transferring whether it will be proper. I said we should file response. My laws raised the same objection. It was very justified. So we filed the response. Then we are now pressing that IA. So we have brought on record P8 as R8 as well, my lord. This is no more rest in the this position of law is settled, my lord.
So that judgment, that order, Mr. Agrawal, is an order in rem.
Yes.
Now, without seeing the facts and circumstances of those people who are not before the court,
It was consciously passed.
there are only 14 people.
It was consciously passed. Not the court was aware of this situation. The point was, my lord, that in case they are permitted to transfer other employees except these petition, my lord, then that will open a floodgate. Now, because the validity of the rules itself is under challenge, my lord, and prima facie the rules, my lord, the authority, my lord, the state government does not appear to be the competent authority to frame rules. Therefore, this order was passed so that other employees are not. Let me complete. I don't interrupt when you argue.
All right. So then we'll post this matter of final hearing instead of vacating.
But I'm not seeking vacating. I'm only seeking leave, my lord. And I was also present, my lord, when the matter was being argued. In fact, this honorable court only to ensure that there is no mischief as to the sole purpose of these rules is not to seek their transfer, impose this condition, my lord. So this is not after a long time we are seeking transfer, my lord. And because the administration of these institutions were not being properly, a person who is continuously posted for a long duration at the same institution, they tend to, my lord, the anti-incumbency concept comes into play, my lord.
They tend to develop a vested interest.
So they are employees of
The administration is not properly what the petitioner want. So place, my lord.
Employees of institute,
They are
they will die there.
हमने अपना जवाब प्रस्तुत किया है कि सारे सिलेक्शंस स्टेट लेवल से हुए हैं और सिलेक्ट करके हमने रिक्रूटमेंट करके उनको भेजा है कॉलेजेस में और कभी भी कंप्लीट ऑटोनॉमी नहीं दी गई है कॉलेजेस को और my lord, we are only doing so in the interest of the institutions. We are receiving complaints from these institutions that these persons are posted there since a very long period of time.
Where is that?
I was simply seeking leave of this honorable court to transfer because the petitioners are not
No,
the
where is that
principals.
material that you are receiving complaints against them?
My lord, I in fact asked them as to why you want to transfer them. That
No,
is
in your IA,
the reason that we have stated that
you must have said it in your IA that there are some complaints.
IA में ये लिखा है कि बहुत लंबे समय से लंबी अवधि से पदस्थ. The reason is that my lord,
अवधि alone cannot be
complaints are not explicit. The manner in which they are functioning, we realize it over a period of time that there is a need that to make it more to ensure that the functioning is
We'll
proper.
hear it finally in the final hearing list. लिखिए इसमें IA 13223 of 20.
माय लॉर्ड का स्टेटल पोजीशन है माय लॉर्ड. कोई भी ऐसा रिलीफ जो फाइनल रिलीफ के बराबर हो नहीं दिया जा सकता. इसमें उसके हमारे अगेंस्ट हो गया है.
ये कौन सा रिलीफ?
ये जो रिलीफ दिया गया है सभी को ट्रांसफर नहीं किया जाए वो वास्तव में उस कानून पे ही स्टे हो गया है. सभी कानून पे इससे लिखा नहीं गया है तो इस तरह से हो गया. ये
फाइनली सुन लेते हैं जल्दी.
नो ये पढ़ लीजिए माय लॉर्ड. उसमें कैसे पावर है मैं वो बता रहा हूँ. 309
फाइनली सुन लेते हैं जल्दी.
हाँ तो ठीक है सुन लीजिए.
जुलाई में सुन लेते हैं.
माय लॉर्ड जुलाई में नहीं माय लॉर्ड ये साल भर से ज्यादा हो गया माय लॉर्ड. हम सिमिलर सिचुएशन हैं. ये चूंकि शहर में है भोपाल में है और ग्वालियर में तो चाह रहे हैं ट्रांसफर ना हो. जो बेचारे गांव में है वो चाह रहे हैं हमारा ट्रांसफर हो. ट्रांसफर नहीं हो पा रहा है और ये चाहते हैं कि हमारे वहीं पर बने रहे कोई ना कोई बहाना लगा करके. और ये जो ऑर्डर हो गया मैंने पिटिशनर को रोका जाए पिटिशनर के ट्रांसफर को रोका जाए यहाँ तक तो सर सहमत है. लेकिन सिमिलर सिचुएशन को रोका जाए मतलब ये हमारे लिए आपत्तिजनक है. कोर्ट को जो पक्षकार हैं उनके इशू को डिसाइड करना चाहिए न कि कानून बनाने का काम करना चाहिए न्यायालय माने. जो रूल्स बना के उसकी वैलिडिटी डिसाइड हो जाए मेरा तो ठीक है. आर्टिकल 309 पढ़ दो मैडम ने मैरिट.
हाँ पढ़ी.
आर्टिकल 309 रिक्रूटमेंट एंड कंडीशन ऑफ सर्विस ऑफ पर्सन सर्विंग द यूनियन आर a स्टेट subject to the provision of this constitution. Acts of the appropriate legislature may regulate the recruitment and condition of services of persons appointed to public service and posts in connection with the affair of the state affair of the union or any state में. तो यहाँ गवर्नमेंट सर्वेंट की कहीं पर बात नहीं मिला. पोस्ट इन कनेक्शन विद द अफेयर ऑफ द यूनियन और एनी स्टेट है मतलब. ये जो गवर्नमेंट कॉलेज है गवर्नमेंट का अफेयर है वो गवर्नमेंट अफेयर में ही काम करता है. प्रोवाइडेड दैट जिसके तहत कानून बना गया प्रोविजन में प्रोवाइडेड दैट इट शैल बी कॉम्पिटेंट for the president or such person as they may be directed in case of service and post in connection with the affair of the union and for the governor of a state or such person as may direct in the case of services and post in connection with the affair of the state to make rules regulating the recruitment and condition of services of persons appointed to such service and post until provided in that is made or under any act of the appropriate legislature under this article and any rules so made shall have effect subject to the provisions of any such act. यहाँ पर मेरा कहीं पर नहीं कहा गया कि वो गवर्नमेंट एम्प्लॉय होना जरूरी है. जो गवर्नमेंट के अफेयर्स हैं उसमें किसी में भी वो अप्लाई होता है. गवर्नमेंट कॉलेज है तो स्पष्ट रूप से गवर्नमेंट का अफेयर है. गवर्नमेंट के यहाँ पर फंडिंग होती है इसके ये स्पष्ट प्रोविजन है कि गवर्नमेंट अफेयर है इसलिए गवर्नमेंट से फंडिंग करता है. पूरे होली गवर्नमेंट फंडेड है. जो कॉलेज जो रन हो रहा है पहले गवर्नमेंट ही तो ऑटोनॉमस दिया गया है ये जो ऑटोनॉमस बनाने की जो बायलॉज बना सर, बायलॉज को पढ़ लेते बड़ा क्लियर हो जाएगा इनकी क्या स्टेटस है इसमें। ये कैसे अफेयर ऑफ स्टेट नहीं है, इनकी ड्यूटी जो है अफेयर ऑफ स्टेट नहीं है कि कैसे कर रहे हैं।
इसमें लिखिए IAS also is taken up, considered. The learned counsel for rival parties are heard on the said IA, which is filed by the state, praying for.
My lord, instead of deciding it, my lord, it's listed for final hearing. My lord, they say instead of deciding.
Either you withdraw this.
My lord, I don't have instructions as of how to withdraw it, my lord. I'll seek instructions, my lord. A short time may be given.
इसमें बायलॉज थोड़ा देख लीजिए एक बार।
Learned counsel for the state. That during the course of arguments on IAS also, learned counsel for the state prays for some time to seek instructions as to whether the state would like to press IA 13223 of 22. Considering the nature of the dispute and the pleadings being complete, list for hearing on the top of the list for hearing at the end of the motion hearing list.
मैडम नेक्स्ट वीक कर दिया जाए, उससे लंबे क्यों किया जाएगा, इस साल भर से ज्यादा हो गया।
On
और इससे चारा मैडम की आईए पर डिसाइड हो जाएगा
on 12th और 13, दोनों में से कोई नहीं, जुलाई।
Number 41. 72.
Yes.
My lord, this arbitration revision is against the award passed by MP Arbitration Tribunal, my lord. The petitioner had filed 3 reference cases, my lord, before the learned tribunal, and by common award, the tribunal dismissed my 3 cases. In the respondents had also filed counterclaim, my lord. Their counterclaim was dismissed by the honorable court.
Let the record come, then we'll record. The tribunal will be requisitioned list after receipt of the record.
Number 42.
Identical matters.
Same record.
Right.
Number 43. शुभम कुमार मिश्रा।
लॉर्डशिप, इसमें हमने डाइवोर्स डिग्री को चैलेंज किया है फर्स्ट पार्टी में, फर्स्ट अपील में। लॉर्डशिप, ये एक्स पार्टी डिग्री थी श्योर में, हमको पता है इसमें 272 डेज का लॉर्डशिप डिले है, क्योंकि एक्स पार्टी ऑर्डर था, हमें पता नहीं था।
913 पेश करिए आपने
लॉर्डशिप 913 तो पेश नहीं की।
सेटिंग असाइड एक्स पार्टी डिग्री।
यस लॉर्डशिप, उसको
पेश करी थी आपने?
फर्स्ट नहीं, सॉरी 911 लॉर्डशिप इसमें पेश नहीं किए। सेटल साइड नहीं लॉर्डशिप, 911 पेश नहीं, अभी इस पे डिले के लिए आज लगा था।
913 पेश करिए फिर
लॉर्डशिप, कर देते हैं, 1 वीक का टाइम दे दें। फोन साइलेंट है फिर।
It's quite a weird ringtone. Never heard such kind of ringtone.
नहीं लॉर्डशिप, रिंगटोन नहीं है ये। अब वो देखो ना क्या इशू है, रिंगटोन नहीं है, साइलेंट ही था, आने से पहले कर दिया।
We don't want any musical background to your arguments.
इसमें लॉर्डशिप
नहीं, 913 का ऑर्डर कहाँ है?
913 का ऑर्डर
तेरा ऑर्डर नहीं है लॉर्डशिप इसमें।
Hmm?
1 week का लॉर्डशिप टाइम दे दे।
The challenge herein, the challenge made by the wife, no,
Yes, Lord.
husband herein.
नहीं, हमने वाइफ
The wife herein is to an ex-party decree of divorce passed in favor of the husband.
Yes, Lordship.
By the family court. Next para. Learned counsel is directed to find out as to whether any application under Order 9, Rule 13 was filed by the wife or not. List after
one week, Lordship.
After 1 week.
Oblige, Shubham, Mr.
Bill number 44, initial approval.
My lord, this matter pertains to DP1 as the virus has been challenged, wrongly listed in the category of taxation, my lords. It has to be category of ultra virus, my lords.
Where is the challenge?
7.3, my lord, relief 7.3, 7.4, my lord, says that we have challenged the particular notifications on the basis as it being unconstitutional and contravention to the entry 50 of list 2 of 7 schedule of the constitution, my lords, as well as other circular as well as 45th meeting of the GST council, my lords.
No, challenge is to a notification.
Notifications.
Does it have any statutory force?
My lords, yes, my lords.
Where is the notification?
No, P5, my lords.
Page?
P5, my lord, so that page number is, my lord, 63, my lords. And particular.
It's a statutory note.
Yes, my lords.
Right. Well, say that since the challenge herein is to a statutory notification P5, this matter appears not to belong to the roster of this bench. Next, registry to verify and place it before the right bench. ये allotted तो नहीं है आगे.
Similar matter already.
Time DB1 में लगा.
Last, not similar matters also went before DB.
No, last time it was listed before DB1.
No, no, there is a similar case I have annexed along with it.
It's all right. Yes.
This is also need to.
Yes.
Bill number 45, the round person have to.
Your Lordship, the matter is of single bench, Lordship. Similar matter has been decided by single bench.
Yeah, matter.
Matter that it was listed day before yesterday for ascertaining as to if the matter belongs to the DB or single, Your Lordship.
ये का क्या note होगा ना इसमें registry में?
Previous order में kindly see.
इसमें challenge क्या किया है?
इसमें Lordship challenge ये है कि all the petitioner belong to reserve category. While issuing the appointment order millard the benefit of the
उसमें EWS वाले भी हैं.
हाँ EWS हैं.
Reserve category के नहीं होंगे.
नहीं reserve है sir. EWS one of the reserve category in the state of Madhya Pradesh.
Then but EWS में जो लोग आते हैं वो reserved category के नहीं आते हैं.
नहीं सर EWS
SC ST OBC में से नहीं होते हैं.
ST ST OBC नहीं
reserved होते हैं.
लेकिन जो EWS है it is one of the reserve category. OBC, SC, ST and EWS. They are 4 category of vertical reservation.
Similar matters शायद एक बार आ चुके हैं.
Yes, this similar ये जो ऑर्डर हेलो साहब का है ये ऑर्डर अलग है सर. ये ऑर्डर का इस केस से कोई रिलेवेंसी नहीं है. ये वो वाले कैंडिडेट है इस ऑर्डर में के जो कैटेगरी से कैटेगरी में अपॉइंट हुए हैं. ये है सर ऑर्डर मैंने दिए थे परसों और ये फिर से मैं दे रहा हूँ. ये सर गरिमा पटेल का आदेश है और AEWS का आदेश है अमन दुबे.
EWS और इसमें OBC वाले भी हैं.
हाँ
EWS वाले भी हैं.
EWS वाले भी हैं, OBC वाले भी हैं और SC वाले भी हैं. मैं काइंडली सी पैरा नंबर 5.5 इसमें हमने लिखा हुआ है कि पिटिशन नंबर 7 SC का है petitioner number 1 to EWS and 11 EWS, 13 EWS, and remaining OBC.
तो रिप्रेजेंटेशन करने को कह रहे हैं।
हाँ सर, वही मैं इसमें चाह रहा हूँ।
वही चाह रहे हैं।
हाँ वही चाह रहा हूँ।
तो दिखाइए इनको।
हाँ सर।
Can we pass this order? Their claim be considered, ये लिखा है।
Yes, my lord, in light of the judgment of Honorable Apex Court part in the Praveen Kumar Kurmi case.
वो कहाँ है?
इसमें लगा हुआ है सर, मैं कर लीजिए पेज नंबर 306 P8
306 और भी है इसमें? अच्छा ये
इसमें
नहीं थी।
May I read this?
Oh, we have read this order.
जी। क्योंकि पुलिस रिक्रूटमेंट में भी इसी प्रकार का इन्होंने एसएफ में रिप्लेस कर दिया था।
इसमें लिखिए दैट अभी क्या स्टेज है रिक्रूटमेंट की?
स्टेज चल रही है, स्टेज चल रही है रिक्रूटमेंट की अभी।
नहीं चल रही है नहीं, this is not the answer.
नहीं, they are appointed to the tribal welfare department and they have given joining.
Who has given joining?
All petitioners. All these petitioners given joining in the tribal welfare department. They have of the choice.
अब क्या फर्क होगा अगर आप जीतेंगे तो?
जीतेंगे तो हमको हमारी चॉइस के हिसाब से स्कूल एजुकेशन में हमको पोस्टिंग चाहिए।
अच्छा डिपार्टमेंट।
हाँ, I am not opt a single school of tribal welfare department.
Already, Learned counsel for the petitioner. आप या इंस्ट्रक्शन ले लीजिए आप। whether
Your
you
Lordship, I'll seek instruction.
all right. Learned counsel for the petitioner prays for a short relief or a direction to decide the representation annexure.
सभी ने नहीं दिया है सर, प्रेस रिप्रेजेंटेशन देंगे इसमें। Only some of the petitioners.
Direction
P9
to enable the petitioners to file a representation and thereafter for the state to consider the same. In the light of the decision of the apex court in the case of Praveen Kumar Kurmi versus State of MP, civil appeal so and so, decided on 24 February 22 by the P8 and similar orders passed based thereupon by this court, by single bench of this court in so and so and so and so. Next paragraph. State Council is directed to seek instructions as to whether this petition can be disposed of with the aforesaid direction. List
and to respondent number 2 को direction respondent number 2
list after a week. Sure.
After week कर रहे हैं सर इसको।
After 1 week है। Password number 4. Yes.
Please, Lordship. Lordship, in this petition, I have challenged the order, which is.
Which order are you challenging?
My Lord, annexure E7, my Lord.
Page number 523. What is this order? Page
75 onwards, my Lord. The operative portion is at page number 78, orders passed by the learned DRT Jadavpur, my Lord, whereby my application for recalling as well as prayer for interim relief has been rejected without considering the merits of the case, my Lord.
Who are you?
But I am the borrower, my Lord.
Borrower. So this is a securitization application.
Yeah, yes, my Lord. It's an application under section 17.
Why can't you go to the appellate for
my Lord, may kindly see this order has been passed without exercising the jurisdiction vested upon the learned DRT for checking the measures taken under section 13(4) and 14, my lord. Because, my lord, my application has been rejected on the ground that we have not complied with an order dated 2/2/2023, my lord. Wherein, my lord, what has happened earlier, the learned DRT has simply adjourned the matter with on the submission that we will deposit certain amount. And at that time, my lord, DRT has not considered the even the section 5 application. It was kept pending and matter was adjourned with the observation that it could be settled amicably. When it could not be settled amicably and the amount is not deposited, I pressed for my interim relief, my lord. Thereafter, my lord, by this order, my application for section 5 for limitation was allowed. But interim relief, prayer for interim relief has been rejected without touching the merits of the case, my lord.
No, आप ही के कहने पे ये ऑर्डर पारित हुआ है 2/2/23.
My lord, may kindly see
certain terms and conditions. You did not comply with the same. Why should the tribunal help you then?
My lord, my humble submission, my lord, may kindly see what was the order, my lord. My lord, may kindly see the earlier order.
You were granted a stay on deposit of certain amount of money.
But at that time, my lord, it was an interim interim protection without considering, without even touching the merits, my lord. It was matter was simply adjourned. And at that time, may I read the order, my lord? It is at page number 43.
No, we can't help you.
Yes, my lord, may kindly see. And right
now, the appellate forum.
Right now, we have deposited 20 lakhs also, my lord. As per my lord,
appellate.
My only prayer is that matter may be.
Why should the DRT help you? Once you say that yes, I will deposit, then you say I don't.
My lord, may kindly see what has happened in this matter, my lord. In para number 4 of this.
Are you ready to go to the appellate forum or not?
My lord, my humble submission, my lord.
We are not going to entertain these matters on merits.
No, since pure question of law is involved, my lord, for the reason that whether DRT was right enough, whether
you have gone back on your words.
My lord, may kindly see the order. What was the order? If just for a while, my lord, para 4 of the order be seen 2/2/2023 का जो order है, इसमें court ने adjourn किया था. What was the observation made? And I have moved an application to show कि banks हमने.
Where is the order?
Page number 43, my lord. P2. My lord. Here, my lord, I am reading from the first para, second para, my lord. Applicant counsel fairly submits that the applicants are voluntarily agreed to deposit rupees 20 lakhs within 10 days and prays for adjournment to hear application for continuation of delay subject to interim protection against the execution order. Respondent counsel, by opposing the prayer, submits that the applicants are not entitled to protection since essay is time barred. In the opinion of this bench, since the applicants are voluntarily agreed to deposit rupees 20 lakh with the bank against outstanding, therefore matter may be adjourned for some time so that the matter applicants may settle the dispute amicably with the respondent bank.
Provided you deposit that.
My lord, what has happened? I have moved an application thereafter, my lord. We have approached the bank. Bank was not ready to settle the account. They were asking 75 lakhs, my lord.
Did you deposit till 11 to 23?
My lord, since at that time they were not ready to settle the account at that amount, on that amount, my lord. Because, my lord, what is earlier years was sanctioned at 30 lakhs. Now, my lord, we were depositing more than 75 lakhs, and that I have stated in my application also.
Then you read para 7 of this order, of this very order.
If the applicant, yes, my lord, if the applicants remain failed to comply this direction, respondent bank is free to execute the order.
Consequence of non-compliance is also given.
My lord, my humble submissions. What my humble submission, my lord? In fact, my lord, matter was not at all. At that time, my lord, section 5 application was not at all allowed.
Mr. Counsel, this is a frivolous petition. We'll impose cost if you continue to argue.
But in that case, my lord, I may permit you to withdraw, my lord, and at least, my lord, this matter is listed for 20th of July, my lord. The DRT may be directed to dispose my case various expeditiously, my lord.
The petitioner, after arguing for a while, prays for withdrawal of this petition with liberty to pursue his cause before the DRT, which is pending in shape of essay number?
Essay number
1023 of 22.
22, my lord.
With the aforesaid liberty, the petition stands dismissed as withdrawn.
So in that case, my DRT may be directed to dispose it expeditiously because pleadings are completed, my lord. Pleadings are completed is mentioned in the order.
I don't know because the other side is not here. How can we make that order?
But if an observation for expeditious, that that will also firm. No, not the time frame, only expeditious, but direction may be.
No, we don't know whether they are delaying it or because of the tribunal, or you are delaying it or they are delaying it. We have no idea.
Although, my lord, in the order itself, it is mentioned that pleadings are complete and matters to be heard finally, and pleadings are completed.
So you make a request there. If they don't listen to you, then you come to us.
My lord, I'm obliged.
Bill number 27, Classic Poet, Vikas Sharma.
कौन सा 27?
My lord, in the first round, SSC is not appearing from the last 3 times.
It's not well. उसके बाद none for the appellant. No bars are those. All right, as a matter of last indulgence, it is observed that on the last 2 occasions, 20-4-23 and 12-6-23, the matter got adjourned for reasons attributed to the petitioner, for the appellant. However, to ensure a last opportunity to the appellant to be represented, list the case after 2 weeks. Okay. ठीक कौन सी 12:45 ठीक so the special bench will be at 12:45.
Malum, we just have a look at the first order, 9/3/2022. That's the first order.
First rejection.
Yes, Malum. When counsel for the appellant, after arguing for a while, place for withdrawal of IA number so and so, an application under section 389 of the CRPC for suspension of transmitters moved on behalf of the appellant with liberty to reveal the court after suffering some reasonable period of custody. This was on 19/3/2022. Now, sir, he is there in custody since 13/6/17. When we look to the evidence of the doctor, my lord, none of the injuries have been caused on the vital parts. The injuries are on the non-vital parts. But let me just have a look at the evidence of PW 14 and 18, my lord.
What is the custody period now?
Now, my lord, this more than 6 years, sir. सर ज्यादा से ज्यादा ये 325 जाएगा या 304 पार्ट 2 में जाएगा, इससे ज्यादा नहीं जाएगा ये.
मेरिट्स पे डिसाइड नहीं हुआ.
ये मेरिट पे नहीं, सर. The doctor says none of the injuries they were caused on the vital part of the bodies.
What is the allegation?
Sir, para 3 of the judgment में करनी चाहिए, sir.
डिसीज का नाम क्या है?
मोहम्मद इकबाल. शादी बंकुल वर्ष 2003 में मोहम्मद शफीक से किया था. शादी के बाद से ही उसकी लड़की रेशमा, उसका दामाद व उसका भाई नफीस एकदम शरीर परेशान करते थे. मारपीट कर पैसों की मांग करते थे, लेकिन वे लोग समझा बुझा देते थे. रमजान के महीने में दिनांक 4/6/2017 को वह लोग अफ्तार के लिए अपनी लड़की रेशमा एवं उसके ससुराल वालों को बुलाने गए थे, तो नहीं आए. लड़की को भी नहीं भेजे तथा उसे मारपीट किए तथा 3 लाख रुपए की मांग किए. नहीं देने पर तलाक की बात करते थे. उसका दामाद शफी, उसका भाई नफीस मालूम एवं शरीफ तथा उसकी माँ शबरीन सभी बोलते थे 3 लाख रुपए दोगे तभी भेजेंगे, नहीं तो तलाक दिलवा देंगे. दिनांक 9/6/17 को शाम 45 बजे वह तथा उसका लड़का अलीज उर्फ प्यारे लड़की को लेने उसके ससुराल गए. रेशमा को भेजने को कहे. दामाद शफी एवं उसकी माँ शबरीन बोले नहीं भेजेंगे और गाली देने लगे. तो उन्हें समझाते हुए घर पे बाहर रोड पर शफीक का बड़ा भाई मोहम्मद शरीफ उसे पकड़ लिया. शफीक तथा उसका छोटा भाई नफीस दोनों उसे चाकू से मारपीट करने लगे. शबीर कहने लगी कि चाकू से नहीं, उसे बंदूक से मारकर खत्म कर दो. उसे चाकू पीठ में उसकी बाएं हाथ में लगी एवं घटना सुनकर उसका बड़ा लड़का इकबाल आया तो शरीफ, शफीक व नफीस तीनों ने मिलकर उसके लड़के इकबाल को उसकी हत्या करने के उद्देश्य से धनाधन चाकू से मारने लगे तथा वह उसका लड़का इकबाल दोनों घायल होकर जमीन पर गिर गए. लड़का अलीज उस प्यारे ने बचाव करने की कोशिश की, उसे भी चाकू से चोट पहुंचाई. मौके पर मोहम्मद कौसर, मोहम्मद सेंसो सबसे Para 12 is where the evidence of the doctor has been discussed. Conducted BMLC. तो साक्षी डॉक्टर अभय श्रीवास्तव वीर साक्षी 14 ने para 12 of the judgment. उक्त साक्षी डॉक्टर अभय श्रीवास्तव ने अपने कथन में यह भी बताया कि आहत को उपचार देने के बावजूद आहत की मृत्यु दिनांक 6/2017 को रात 11:30 बजे हो गई. इलाज की मूल प्रति प्रदर्श की 17 है जिस पर उसके हस्ताक्षर हैं. 19/6/17 को आरक्षक मनोज दुबे थाना उमती में उसके सामने 2 जागरूक पेश किए गए जिसकी क्वेरी रिपोर्ट चाहिए गई. क्वेरी रिपोर्ट सो है 13. उक्त साक्षी डॉक्टर अभय श्रीवास्तव ने अपने प्रतिपरीक्षण में बताया है 17 के मुख्य पृष्ठ पर समय 6:45 नीली शाही से लिखा है, शेष इबारत काली शाही से लिखी है. आहत को एक छोटे वाइटल पार्ट पर थी. 3 बार
And who was conducted the postmortem. And then para 15 में kindly be seen, Marlo. Para 15 at page 9. Where the evidence of Dr. Srivastava PW 18 has been discussed.
Para?
Para 15 at page 9, my lord. That will be part of para 15 only at page 9.
What is the opinion of doctor in regard to these three?
नाइन में डिस्कस करें इस साक्षी के अनुसार मृतक की मृत्यु का परीक्षण प्रारंभ करने के समय से 24 घंटे के भीतर थी। मृतक की मृत्यु का कारण बाएं हाथ में मृत्यु से आई चोट उसका दुष्परिणाम थे जो कि ठोस एवं ओपन वाली वस्तु से आई थी जिसके द्वारा दी गई शव परीक्षण रिपोर्ट प्रदेश P22 से 22 निकालिए।
मृत्यु का कारण बाएं हाथ में मृत्यु पूर्व में आई चोटें। बाएं हाथ में कौन सी चोट? एक कटा हुआ घाव अग्र घाव बाएं पुट्ठे के ऊपर।
तुम्हारे पास then para 25 of the judgment may kindly be seen, sir. That is certain and grave provocation.
Para
25.
Yes.
साक्षी मोहम्मद इम्तियाज, आई एम रेफरिंग टू para 25 दी जाए। साक्षी मोहम्मद इम्तियाज अभिजीत साक्षी 13 ने अपने मुख्य परीक्षण बताया कि घटना दिनांक को दूध लेने अपने घर से निकला था, तब शरीफ की पत्नी भागते हुए आई और बोली कि घर में यूनुस से उसके दामाद की लड़ाई हो रही है। फिर वह 2-3 लोग उसके घर गए, तब यूनुस को बाहर लेकर आए। तत्पश्चात यूनुस का लड़का रुस्तम इकबाल आया, गाली गलौज करने लगा। इन लोगों ने गाली गलौज करने, सो इट इज अ डिसीज हु वाज अब्यूजिंग मालूम। इकबाल आया, इकबाल वाज अ डिसीज। इकबाल आया, गाली गलौज करने लगा। इन लोगों ने गाली गलौज करने से मना किया। उतने में शरीफ आया और शरीफ ने यूनुस को औजार से मारा, जिसे देख नहीं पाया था। नफीस ने रुस्तम को मारा। इस साक्षी ने प्रतिपरीक्षण में बताया कि घटना के पश्चात रुस्तम उर्फ इकबाल इमाम अजीम उर्फ वह अपनी मोटरसाइकिल से जबलपुर अस्पताल ले गया। घटना के समय मोहम्मद कौसर, मोहम्मद शहबाज उपस्थित नहीं थे। इस साक्षी ने यह भी बताया कि रुस्तम उर्फ इकबाल घटनास्थल पर आया एवं आते ही नफीस व उसके परिवार वालों को गाली देने लगा। उसे समझाने पर शफीक ने none of the injuries are the vital part model and para 38 में also seen where the issue has been summarized in para 38, sir. Para 38, sir.
Yes.
प्रकरण के बिंदु पर विचार करना है कि क्या आरोपियों द्वारा मोहम्मद इकबाल की मृत्यु कारित किए जाने हत्या अथवा हत्या से भिन्न अपराधिक माना जाता है। तब उक्त संबंध में आरोपी की ओर से अधिवक्ता द्वारा यह तर्क किया गया कि आरोपीगण का आशय मोहम्मद इकबाल को हत्या करने का नहीं था। आरोपीगण व आहतगण के बीच अचानक झगड़ा हो गया, जो गंभीर और अचानक प्रकोपन के कारण आरोपीगण द्वारा मोहम्मद इकबाल के साथ चाकू से मारपीट की गई। आरोपीगण द्वारा बिना किया गया, इस कारण आरोपीगण का अपराध धारा 304 भाग 2 के अंतर्गत आता है। To summarize, I would say, my lord, in fact, there was an abuse which took place from the other side. On account of that, these knife blows were given. None of the knife blows landed on the vital part of the body. At the most, my lord, this would be an offence punishable under section 4 part 2. Now, 6 plus more than 6 they have already undergone.
So the death is caused because of which injury?
उन्होंने कहा हाथ में आने से हुई है सर, मैंने जो पढ़ के बताया था।
हाथ से डेथ कैसे होगी?
सर हाथ से कोई वेन कट गई होगी सर।
No, it is the other injury, I think.
PW18 देख ले सर।
No, because there was an injury which pierced the anus also. They were bleeding there.
No, but that is not the cause of death, no. That is not the cause of death. But we just have a look at the evidence of PW18. शव परीक्षण के दौरान मैंने निम्नलिखित छोटे जैसे उसी जो बाएं हाथ की चोट है उसी से डेथ होना कह रहे हैं सर।
राहें कटी हुई
नीचे को करो। So it's clear from PW 18's evidence.
Lord से para 15 में आया जी.
और डॉक्टर ये भी कहा कि इनका इलाज हो जाए तो बच जाते.
ये कहाँ का है?
पर ये पैराग्राफ 3 में PW 18. PW 18 की गवाही थोड़ा सा देख लें आप.
हाँ वही देख रहे हैं.
सर पहले उन्होंने बोला है मृतक के जो बाहर मृत्यु पूर्व चोट बताई गई है, एक है मृतक के बाएं हाथ के सामने वाली भाग में एक सिला हुआ घाव मौजूद था जिसका आकार इतने सेंटीमीटर जो कि बाईं कलाई से 8 सेंटीमीटर ऊपर था. कलाई के रेडियल और अल्ना शराएं कटी हुई थी. दिस इज द रीजन मालूम. These arteries they were cut down or veins were cut down. This is the reason for the loss of blood मालूम. Then मृतक के बाएं कूले में एक सिला हुआ घाव मौजूद था जिसका आकार स्वयं था. चोट क्रमांक 3, चोट क्रमांक 2 के 5 सेंटीमीटर नीचे एक सिला हुआ घाव मौजूद था जिसका आकार स्वयं था. फिर मृत्यु का कारण जहां दिया हुआ है वो देखो. तो मृतक की मृत्यु का कारण बाएं हाथ में मृत्यु पूर्व से आई चोट एवं उसके दुष्परिणाम थे जो कि एवं घोंपने वाली वस्तु से आई थी. चोट के अन्य जानकारी के लिए इलाजकर्ता चिकित्सक से अभिमत प्राप्त किया जा सकता है. मेरे द्वारा दी गई शव परीक्षण रिपोर्ट पैरा 3 सर, दिस ऑल्सो इंपॉर्टेंट. यह सही है कि आहत को जो चोट क्रमांक आई थी नॉन वाइटल पार्ट पर आई थी. यह सही है कि मैंने आहत की मृत्यु के विषय में जो अभिमत दिया है वह अभिमत चोट क्रमांक 1 के आधार पर दिया है. यह सही है कि यदि चोट क्रमांक 1 तत्काल उपचार हो जाता तो मृतक की मृत्यु नहीं होती.
He only states about 2, 3 and 4, not 1.
मतलब
Not 1.
He says the cause of death is injury number 1 only. He is only saying that. बाकी तो वो है ही नहीं ना छोटे, उसका कॉज ही नहीं है डेथ का. उसने स्पेसिफिकली कहा है कि चोट नंबर 1 is the reason for the death. And therefore the cross examination is confined to injury number 1 only. Now he is there in custody. This will also come down the complaint party they were abusing initially, and this was the reason why it happened. So there are few judgments जहाँ non-vital parts पे ऐसी injuries आई हैं where the court has converted those. May I refer to those judgments?
Yes, sir.
So this is 2012 volume 4 SCC, 564, paragraph 10 to 15.
2012 volume.
Volume 4 SCC, pages 564.
Which para?
Para 10 to 14. We heard the line pass for the parties at some length and produced the record. The court was in our opinion justified in holding that the prosecution had not been able to establish the charge of murder beyond reasonable doubt. The High Court has correctly observed that the proposition of Dr. Naresh Rao PW13 has clearly established that the injuries sustained by the disease were all simple in nature, inflicted upon non-vital parts of the body. The doctor had also clearly admitted in the cross-examination that no findings were recorded in the post-mortem report exhibits also that the injuries and questions were sufficient in the ordinary course of nature to cause death. There was, in that view of the matter, in the absence of any other evidence to support the charges leveled against him. It is noteworthy that the trial court had placed heavy reliance upon the presence of the blood clots below the scalp and inside the middle portion of the skull of the deceased, come to the conclusion that the death may have been caused by the injuries on the head, which is the vital part of the body. There is not even a single injury on the vital part of the body, Malo. The trial court obviously failed to note that there was no external injury reported by the doctor or any part of the head. If the respondent intended to commit the murder of the deceased and they were armed with weapons like lathis and riyas, in which the latter is a sharp-edged weapon, it is difficult to appreciate why they would not have attacked on any vital part of the body. The absence of any injury on any vital part, and particularly the absence of the external injury on the skull, clearly shows that the accused had not intended to cause the death of the deceased, nor cause any bodily injury as was likely to cause death. It is also difficult to attribute any knowledge to the respondent and the injuries inflicted by them likely to cause death, the same being simple in nature. Even the doctor who conducted the postmortem did not certify that the injuries to be sufficient to cause death in the ordinary course of nature. Here also it has not been certified that the injuries were sufficient in the ordinary course of nature so as to
clause thirdly of section 300, my lord. The other judgment which I would be relying upon. The other judgment I would not read, 1981, volume 3, SEC, pages 331. So I submit, my lord, that in fact, when we look into that's an injury on the hand. कहते हैं कि रेडियल वालना की
No, 81 volume.
Volume 3, sir. Pages 331.
331.
That was a case of solitary injury, my lord. But here I respectfully submit, my lord, looking to the period of custody, my lord. Nearly 6 years or more than 6 years. 6 years.
All right. So let us hear the other side. Yes. State बताइए.
Lordship, in this case, Lordship, there were 3 eyewitnesses in this case, Lordship. PW2, PW4, and PW6, Lordship. Lordship, PW2 Yunus, Lordship. Kindly see, Lordship, the para 22 of the impugned judgment, Lordship. May I read, Lordship?
Incident and the eyewitness have not been denied by me, my lord.
आहत साक्षी अजीम उर्फ प्यारे PW4 ने अपने न्यायालयीन कथन में बताया कि घटना दिनांक को उसका भांजा उसे बुलाने आया था, जबकि पुलिस कथन P प्रदर्श D2 में यह बताया है कि वे लोग उसकी बहन व ससुराल वालों को रोजा अफ्तार के लिए बुलाने गए थे, तब ना तो स्वयं आए और ना ही बहन को भेजा। इस प्रकार साक्षी के न्यायालयीन कथन व पुलिस कथन में विरोधाभास है। आगे साक्षी ने घटना के संबंध में बताया कि वैसे वे लोग जैसे ही आरोपी घर के बाहर निकले तो शफीक और नफीस चाकू लेकर आ रहे थे। वह शफीक के पास गया तो शफीक ने उसके गर्दन पर चाकू चलाया, जो उसके बाएं हाथ पर लगा। शफीक ने उसके पिता को पकड़ लिया और शफीक व नफीस ने उसके पिता को पेट में चाकू मारा। उसी समय इकबाल बचाने आया तो आरोपीगण ने उसके भाई इकबाल को बहुत बेरहमी से मारा। इस प्रकार इस साक्षी के न्यायालयीन कथन में हत्या करने के उद्देश्य से दनादन शब्द का लोप है। साक्षी ने न्यायालय कथन में जो बात बताई वह बढ़ा चढ़ाकर व सोच समझकर बतलाया जाना प्रकट होता है, किंतु आहत गण को आरोपी नफीस व शफीक द्वारा चाकू से मारपीट किए जाने संबंधी कथन में कोई सारवान विसंगति नहीं है। Lordship, the applicant inflicted the injury, Lordship. And Lordship, Lordship, kindly see, Lordship, para 29, Lordship. PW6, eyewitness अब्दुल। मामले में अब्दुल मुनाफ खान, जो कि घटना का स्वतंत्र साक्षी है, उक्त साक्षी ने अपने मुख्य परीक्षण में घटना का समर्थन किया है तथा प्रति परीक्षण में यह बताया है कि घटनास्थल पर झगड़ा चल रहा था। घटनास्थल पर आहत यूनुस, मोहम्मद अजीम, प्यारे व इकबाल मौजूद थे तथा इस साक्षी ने भी आरोपी नफीस व शफीक द्वारा मृतक इकबाल के साथ चाकू से मारपीट किए जाने का समर्थन किया है। साक्षी का उक्त कथन प्रति परीक्षण में भी स्थिर रहा है। इस प्रकार उपरोक्त समस्त साक्ष्य से यह स्पष्ट है कि मृतक इकबाल जब उसके पिता व भाई को बचाने आया तो आरोपी नफीस व शफीक ने उसे चाकुओं से मारा तथा घटना स्थल पर उसे जबलपुर अस्पताल ले जाया। लॉर्डशिप, दैट पैरा 50 में आया है कि पैरा 50 में जो रिलेवेंट पार्ट है लॉर्डशिप पेज 42 में ये कि इस प्रकार आरोपी नफीस व शफीक द्वारा मृतक मोहम्मद इकबाल पर बार बार चाकू से प्रहार करने से आरोपीगण का मोहम्मद इकबाल
पढ़ रहे हैं आप?
ये पेज 42 में लॉर्डशिप, पैरा 50 का
ऊपर से
बीच का पार्ट है जो रिलेवेंट पार्ट है कि कैसे उसकी डेथ हुई, ऊपर से 5वीं 6वीं लाइन में लॉर्डशिप। इस प्रकार आरोपी नफीस व शफीक द्वारा मृतक मोहम्मद इकबाल पर बार बार चाकू से प्रहार करने से आरोपीगण का मोहम्मद इकबाल की हत्या करने का आशय स्पष्ट होता है तथा आरोपी नफीस व शफीक द्वारा पहुंचाई गई चोटों से मृतक मोहम्मद इकबाल को अत्यधिक रक्तस्राव हुआ, जिससे चोट की गंभीरता दर्शित होती है। एवं यह स्पष्ट होता है कि आरोपी नफीस व शफीक द्वारा मृतक मोहम्मद इकबाल को पहुंचाई गई चोटें सामान्य अनुक्रम में उसके मृत्यु कारित करने के लिए पर्याप्त थी, इस प्रकार आरोपी नफीस व शफीक का उक्त कृत्य धारा 300 भारतीय दंड विधान संहिता के क्लास 3 में वर्णित हत्या का अपराध है। इस प्रकार अभियोजन यह संदेह से परे प्रमाणित करने में सफल रहा है कि आरोपीगण नफीस व शफीक द्वारा घटना दिनांक को घटना स्थल पर मोहम्मद इकबाल की मृत्यु कारित की गई, जो आपराधिक मानववध होकर हत्या की कोर्ट में आती है।
और सारा झगड़ा इस बात पर है कि वो बहन को नहीं भेज रहे हैं, साले बहनोई का झगड़ा हैगा। बहन को नहीं भेजने पर से ये गाली गलौच हुई और तब ये झगड़ा हुआ है।
6 साल हुआ है।
4 are there.
इसमें मला काइंडली से मला PW2 मोहम्मद यूनुस का मला स्टेटमेंट मला PW2 मला पैरा 2 में आई थी मला पैरा 2 मला जब मैं आरोपी गण के घर पहुंचा तो देखा कि आरोपी गण वहां मौजूद थे और मेरी बेटी रेशमा को रो रही थी। फिर मैं अपनी बेटी से पूछा क्या हुआ, तो रो रही हो? तो उसने बताया कि जब से आपके यहाँ से आई हूँ तो आरोपी गण मारपीट कर रहे हैं, 3 लाख रुपए की मांग कर रहे हैं। मैं उन लोगों को समझाने की कोशिश की तो आरोपी गण हम लोगों से गाली गलौज करने लगे। जैसे ही मैं अजीम वहां से वापस अपने घर के लिए चले तभी शफीक और नफीस चाकू लेकर आए और मेरे बच्चे अजीम के साथ मारपीट करने लगे, जिससे मेरे बच्चे के हाथ में चाकू से चोट आई और जब मैं पीछे हटने लगा तो मुझे पकड़ लिया। फिर शफीक और नफीस ने मुझे पेट में चाकू मारा। नोट माइला कोर्ट का नोट है। साक्षी ने अपना पेट दिखाया जिसमें उसके पेट में दाहिनी तरफ 2 घोंपे हुए घाव के निशान मौजूद पाए गए। मतलब पैरा थी मतलब जब मेरे मतलब कोर्ट का नोट मतलब नहीं मतलब के पिता की मतलब मोहम्मद यूनिस के
जो इंडिया में
पेट में दो साथ दिए थे। जब मेरे साथ मारपीट हो रही थी तो मेरा बेटा इकबाल भी आया। आरोपी शफीक और नसीस ने चाकू से मारा, जो कि इकबाल के आंख में शरीर में और चोटें आई तथा मेरा बेटा अजीम इकबाल अपने बचाने दौड़ा तो आरोपी ने मेरे बेटे अजीम को फिर से चाकू मारा, जिससे अजीम के हाथ में फिर चोट आई। उस समय उसकी माँ सबरून बोल रही थी कि जान से मारना बचने न पाए। जबूदा ने शरीर को छुरा लाकर दिया। हम लोग खून से लथपथ हो गए। फिर हम लोग वहां से ऑटो में जबलपुर अस्पताल आ गए। मतलब चोट का विवरण मतलब एमपीयू डॉक्टर ने दिया मतलब पैरा 11 मतलब जजमेंट का पैरा 11 मतलब।
यस
सर्वप्रथम हमें इस तथ्य पर विचार करना है कि क्या मोहम्मद इकबाल की मृत्यु आपराधिक मानववध है। तब इस संबंध में डॉक्टर अभय श्रीवास्तव अभियोजन साक्षी 14 ने अपने न्यायालयीन कथन में बताया कि दिनांक 9/6/17 को जबलपुर अस्पताल में अस्थि रोग विशेषज्ञ के रूप में कार्यरत था। उक्त दिनांक को 7:10 बजे मोहम्मद इकबाल आयु छत्तीसगढ़ निवासी बंद जबलपुर अस्पताल लाया गया था। वहां बेहोशी की हालत में था तथा उसे अत्यधिक रक्तस्राव हो रहा था तथा आहत को निम्नलिखित चोटें थी। नंबर 1 कटा हुआ घाव बाएं भुजा में था, जिसका
अगर भुजा में था।
चश्मा सराज भूल गए तो नहीं जाते।
अगर भुजा इज फोर आर्म
एक बाएं पुट्ठे के ऊपर घाव जिस पर से खून बह रहा था। एक घाव इनसाइड बोल्ट बाएं पुट्ठे पर घाव क्रमांक 2 के पास एवं प्लेटिंग के रास्ते में
खून बह रहा था।
मर्म स्थल महिला रास्ते के पास था तथा खून बह रहा था। नाक के ऊपर ये भी मर्म स्थल थी माली। ऊपर कटा हुआ घाव था, खून बह रहा था। मतलब इसके बाद पैरा 16 का लिस्ट मतलब
मामले अन्य साक्षी मोहम्मद यूनुस एवं आजिम और प्यारे अभी साक्षी 14 जो मामले में आहत हैं अब्दुल मुनाम खान, उन्होंने भी अपने नाल कथन में यह बताया कि इकबाल और रुस्तम को चाकू से चोटें पहुंचाई गई। पैरा 19 मतलब कंडीशन मतलब पैरा 19 का लास्ट पैरा मतलब उक्त स्थिति में उपलब्ध साक्ष्य के आधार पर यह निष्कर्ष स्थापित होता है कि मृतक मोहम्मद इकबाल की मृत्यु पूर्व उसको चाकुओं से चोटें पहुंचाने की परिणामस्वरूप कायद की हुई थी तथा मृतक की मृत्यु आपराधिक मानव वध प्रकृति की थी। मतलब इसके बाद पैरा 29 मतलब कंडीशन
यस
मामले में अब्दुल मुनाफ खान जो कि घटना का स्वतंत्र साक्षी है, उक्त साक्षी ने अपने मुख्य परीक्षण में घटना का समर्थन किया तथा परीक्षण में यह भी बताया कि घटना स्थल पर झगड़ा चल रहा था। घटना स्थल पर आहत मोहम्मद यूनुस और मोहम्मद आजिम खान प्यारे इकबाल मौजूद थे तथा इस साक्षी ने आरोपी नफीस शरीफ और मृतक इकबाल के साथ चाकू से मारपीट किए जाने का समर्थन किया। साक्षी का उक्त कथन परीक्षण में भी स्थिर रहा है। इस प्रकार उपरोक्त समस्त साक्ष्य से यह स्पष्ट है कि मृतक इकबाल जब उसके पिता भाई को बचाने आया तो आरोपी नफीस शफीक ने उसे चाकुओं से मारा। घटनास्थल से उसे जबरन अस्पताल ले जाया गया। मतलब पैरा 37 मिनट का मतलब उपरोक्त आहत मोहम्मद यूनिस आजिम और प्यारे अभियुक्त साक्षी 4 अब्दुल मुनाफ खान अभियुक्त साक्षी 6 इस साक्ष्य से यह दर्शित होता है कि आरोपी नफीस शफीक द्वारा मृतक इकबाल को चाकुओं से मारकर चार चोट कारित की गई। साक्षीगण का उक्त कथन अखंडित रहा। पैरा 55 माइनर खंडित। बचाव पक्ष ने के अधिवक्ता का यह तर्क है कि सिक्स फैक्टर द्वारा यह अवगतित नहीं दिया गया कि आहत को आई चोट से उसकी मृत्यु हो सकती थी, किंतु उक्त तर्क के संबंध में यह उल्लेखनीय है कि आहत को आई चोट ग्रीवियस श्रेणी की है तथा उक्त चोट के कारण आहत मोहम्मद यूनुस का एक बार ऑपरेशन कर पुनः ऑपरेशन हेतु उसे बुलाया गया था तथा अभियोजन की ओर से उसकी अधिवक्ता नईम खान द्वारा अपने तर्क में आहत का वर्तमान में इलाज होना व्यक्त किया गया। साथ में वर्तमान में इलाज से संबंधित दस्तावेज भी पेश किए गए हैं। इस प्रकार आहत को आई चोट की गंभीरता को दृष्टिगत रखते हुए यह दर्शित होता है कि उक्त चोट आरोपीगण द्वारा सामान्य आशय के अग्रसर से इस आशय व ज्ञान से पहुंचाई गई उससे आहत की मृत्यु हो सकती थी। इस प्रकार उपरोक्त समस्त अभियोजन साक्ष्य यह संदेह से प्रमाणित करने में सफल रहा कि आरोपी नफीस शफीक द्वारा आहत मोहम्मद यूनुस कोई आशय से व ज्ञान से ऐसी गंभीर चोट कारित की गई जिससे साक्षी की मृत्यु हो सकती थी। उक्त तथ्य से आरोपी नफीस और शफीक आहत मोहम्मद यूनुस की हत्या का प्रयास किया गया। महिला 6 साल से भी कम सजा काटे महिला और ब्लडिंग काफी होने की वजह से सर डेथ हुई सर इसकी तरह। अभी 6 साल से कम सजा सर इसके कितने पिटा किया था महिला का एप्लीकेशन
6 साल हो गया
6 नहीं हुए सर अभी
कैसे नहीं हुए 13/6/17 से है
तो अभी 13/6 से तो अभी
क्या
सॉरी सर हो गए 28 से कुछ दिन ज्यादा हुए सर अभी 6वां महीना चल रहा है।
मतलब PW14 and PW18 they are the important witnesses. PW14 is saying sir in paragraph the person who conducted the emergency in para 4 वो तीनों चोटें का उल्लेख क्रमांक 1 से 3 में है। ये नॉन वाइटल पार्ट पे थी।
सर 2 चोट वाइटल पार्ट पे है सर
शफीक नफीस और शफीक क्या ऑर्डर लाइन के grant bail. Okay. And the next one. Yeah.
Bill number 1, Virendra Singh Parihar.
Oh, the corpus is present. है क्या मामला क्या है? भाई इसमें काउंसिल कौन है पिटिशनर के?
धीरेन्द्र सिंह परिहार एंड
कोई क्राइम नंबर रजिस्टर हुआ है
यस लॉर्डशिप
अगेंस्ट?
क्राइम नंबर 334/2023 लॉर्डशिप। ये किसके
334/23
लॉर्डशिप
अगेंस्ट?
किसके खिलाफ? किसके खिलाफ लॉर्डशिप अगेंस्ट नहीं है 363 में फादर ने की।
एफआईआर तो लगी हुई है इसमें, एनेक्स्टर P1 लगा हुआ है एफआईआर। संदेही संगम यादव लिखा तो है, किसने पेश करी है ये? यस। हाँ हाँ बताइए।
15 साल की हूँ।
नहीं, इसमें आपका जन्म तारीख क्या है, याद है? कोई इसमें स्कूल सर्टिफिकेट या कुछ लगा है?
8 अक्टूबर 2007 लॉर्ड।
8
अक्टूबर 2007।
2007।
यस लॉर्ड।
14 15, तो अभी 16 की हुई नहीं है पूरी।
यस, 15 साल।
ओके। इनके पिताजी आए हैं क्या?
यस लॉर्ड।
आए हैं। आप पिताजी के साथ जाना चाहेंगे?
हाँ।
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 कोई समस्या तो नहीं है?
नहीं।
पिताजी परेशान तो नहीं करते? तो ये 30 अप्रैल से आप कहाँ थी?
राजस्थान।
किसके साथ?
अकेली।
घर से अगर चली गई थी तो कोई ना कोई परेशानी होगी घर में।
नहीं, मम्मी डांटी थी इसलिए मैं गुस्सा में चली गई थी।
अच्छा। ये जो आपने दिखाया स्कूल का रिकॉर्ड, ये क्या है?
ये लॉर्डशिप ये सर्टिफिकेट है।
नहीं, कौन सी क्लास का है?
ये है 5th क्लास।
5th का है।
यस।
और आगे का? आपने कहाँ तक पढ़ा है?
हमने 7 तक।
अच्छा। तो 7 के बाद क्यों पढ़ाई छोड़ दी?
स्कूल दूरी थी इसलिए नहीं गई।
स्कूल दूर था?
हाँ।
तो उनको बुलाइए, पिताजी को बुलाइए। उनके वकील साहब कहाँ है? नहीं है, कोई नहीं है। नहीं है तो आए नहीं। तो इनको आप पढ़ा क्यों नहीं रहे हैं?
जी साहब, नहीं कुछ पढ़ा तो नहीं पढ़ा।
हाँ?
नहीं तो जरा खर्चा लंबे स्कूल रही, किराया भाड़ा लग रहा है ऐसे।
अच्छा, आप क्या करते हैं?
मजदूरी के काम।
स्कूल तो स्कूल एजुकेशन तो फ्री है। तो कहाँ पढ़ाते हैं, कौन से स्कूल में जाती थी? तो सरकारी स्कूल तो उसमें तो फ्री पढ़ाई होती है।
हाँ सरकारी में रही, फिर फिर वहाँ के दिन मऊ बन के बीच में लगा कोरोना साहब।
हम्म।
और फिर किराया भाड़ा नहीं पूछ पा रहा, हम मजदूर आदमी, तो बंद कर दी।
नहीं तो इनको पढ़ाइए, कम से कम 10वीं 12वीं तक तो पढ़ाइए। सरकारी स्कूल में तो कोई खर्चा नहीं है।
सरकारी में अब पढ़ाई नहीं होती है।
पढ़ाई नहीं होती है।
नहीं, वहाँ कोई मतलब नहीं, मास्टर लोग बैठे रहते हैं, लड़के पढ़े तो पढ़े नहीं, अपन खेला।
ये भी एक प्रैक्टिकल प्रॉब्लम है। हम्म, हम्म, हम्म। तो आप इनको पढ़ाइए जहाँ भी पढ़ाना है, और अगर कोई मदद चाहिए तो फिर आप
पढ़ाने के
गवर्नमेंट स्कूल में तो काफी थोड़ा अच्छा किया है।
गवर्नमेंट स्कूल में पढ़ाई नहीं होती है, कह रहे हैं।
नहीं, अभी तो सीएम राइज स्कूल का ही अच्छी गवर्नमेंट।
तो आपको हम बाउंड कर देते हैं कि आप इनको इंश्योर करेंगे कि पढ़ाई करेंगे, क्योंकि जाएंगे स्कूल और इंश्योर करेंगे। ठीक, लिखिए इसमें the the corpus is present before this court in person, having been brought by so and so. दोनों का नाम लिख दीजिएगा। Next one. The petitioner who is the father of the corpus has filed this petition seeking a writ of habeas corpus for producing his daughter who according to him is 15 years of age and is missing since these 4-23, in regard to which FIR bearing crime number 334 of 23 has been lodged in PS Mauganj district Riva, alleging offence punishable under section 363 against suspected accused Sangam Yadav. Next one. The corpus who is present in the court does not dispute that she is 15 years of age. Full stop. The school record as produced by the State Council also, in particular the mark sheet of class 5th reveals the date of birth as, इसमें कहाँ लिखा है डेट ऑफ, अच्छा ये 8/10/2007. Next para. The corpus, however, reveals that she is ready and willing to reside with her parents. आपकी माता जी हैं? माता जी हैं आपके?
हाँ.
With her parents. Full stop. The corpus, however, reveals that she has left school education after passing out from class 7th. 7वीं पास कर लिया आपने?
नहीं.
After attending the classes in 7th standard. In कब करा आपने? 5वीं है. 6ठी भी कर ली पास? कब करी है?
6वीं कब पास करी?
Left studies during the course when she was in class 7th, sometime in 2000. कब छोड़ी आपने स्कूल?
कोरोना के पहले छोड़ दिए.
2019-20. That's it. Next para. The father of the petitioner, the father of the corpus, the petitioner, reveals that he is a man of meager means and cannot afford to bear the expense of the education of his daughter. Next para. This court thus directs the State Council, Shri So-and-so, to ensure that the corpus shall be admitted to one of the nearest government schools or to one of the nearest private schools where the quota for right to education में quota होता है ना, under the quota reserved.
डॉक्टर साहब सीएम राज स्कूल है इसमें.
वो कितनी दूर है वहां से इनके यहाँ से?
मऊगंज में है. मऊगंज में है लॉर्डशिप. मऊगंज 3 या 4 किलोमीटर है.
All right, in the CM Rise school or in any of the private schools under the quota reserve, under the free seats quota.
लड़कियों के लिए तो वैसे.
Next para. Let a report in that regard be filed by the State Council. By filing an affidavit of District Education Officer. कहाँ के? Riva. Next part. The corpus be reached to her home, to her parental home, and receipt in that regard be taken from her as well as her father. Next part. The father is also directed to ensure that he will take care of all the necessities and well-being of the corpus. Next one. The petition stands disposed of with the aforesaid directions, but be listed as PUD for ensuring compliance on the 17th of July. Till when the State Council is directed to ensure filing of report in regard to the education of the corpus. ठीक, इनको वहां छोड़ दीजिए, इनके पास घर पे छोड़ के आइएगा। कुछ कहना है और आपको कुछ कहना है?
नहीं।